Do you know, Sergeant, if all the jurors are here? They all are here. Oh, okay. Excellent. Good group. Usually we have stragglers. Yeah, that's nice. That's true. They've been good about getting back from lunch, too. We just need to get another restroom back there because it takes too long on breaks. Uh-huh. They have the plumbing for that, though? Oh, I don't know.
Sir, I would love to, but I got a jam-packed day.
Do we need Ms. Hodges?
Yes, sir.
No problem.
Actually, we always need Ms. Hodges, but we can first.
You sure?
Yeah, Jen's got the first witness.
Oh, okay. Is the defense ready? Mr. Grant, you need a minute? You're unpacking?
I need, yes, about a minute.
So if I tell them to start lining them up, will you be ready by the time they're lined up?
Yes, sir.
And this.
Your Honor, and I believe that there was something that needed to be addressed prior to the medical examiner.
Oh, is the medical examiner the next witness?
Yes, Your Honor.
What was the issue before the medical examiner?
The photos for the state's exhibits, I'm not sure if it's in a composite or it's several photos that they're wanting to admit of the two deceased victims. We've
Right.
already provided a stipulation. Our objection would be to relevance and that there's no probative value to include every single one of these photos. There's a close-up of one of the victims' faces. I think there's two with like tubing and injuries, and our objection would be of relevance and that would not create any probative value, especially for every single one of them.
So there's a lot of them?
No, Judge, it's the same exact photographs that were introduced in the first trial. Nothing has been added. We have limited them regarding Juan Guitron. There's only 5 photographs.
5 of him?
And with regards to Mr. Sergio Guitron, there's 10 to 11 photographs. Nothing has been added. They're the same exact photographs that were used in the first trial. We've been very conservative in the photographs that we have that we're introducing. They simply document entry and exit wounds and photographs of the faces to match.
Do you believe that they comply with the case law regarding autopsy photographs, and that there must be a reason that they're going to be used? You're familiar with the
Yes,
case
Your
law,
Honor.
and you believe that they... Let me take a look.
Yes, Your Honor.
Can I see the stipulation one more time, please?
Was there an objection in the first trial to the autopsy photographs?
Your Honor, that I would have to review. In addition to my argument, we would add a 403 argument. I understand the state's position. Our objection would be that not all of these are necessary to prove the state's case, and that it can be done with fewer in order to preserve what we're arguing in the objection.
Judge, none of these photographs show rods or
Well, let me ask
any
you
internal document.
for example, do you really need both of these? And why? If so, why?
One judge shows the overall individual, and then it's a close-up showing the abrasions to the face, Judge.
Can't you see them on the first one?
That's fine, Judge, if you want to limit.
All right. I mean, just in an abundance of caution, because the case law also says requires the judge to, look at everything and make sure. And when I look at this, I mean, I don't see anything that you can't do with this one that you need this one for. So
It would first show the full body, that there were no injuries to the front torso portion of the body. But if Your Honor is...
Well, I hear you, and then this is a closer up, but you can see the abrasions in the first one. So in an abundance of caution, I'm going to strike 81. That's 81. So I'll strike 81.
Well, Judge, we would ask if you're going to pick... we want the close-up of the facial abrasions.
So you don't...
We would prefer the close-up of the
Okay, well, I should have said, I'll let you pick one of these. You want this one.
Yes, Your Honor.
Your Honor, if I may respond to that just briefly.
Sure.
Just for the purposes of the abrasion doesn't cause anything to the reason for death. I understand the medical examiner will testify that yes, she observed an abrasion. She cannot testify where it came from, when it came from, and she also says that it doesn't contribute to the death. So we would object to that.
All right. I'm gonna allow that one. There's only one of the leg. I suspect the defense has the same argument regarding the abrasion to the leg.
Correct.
All right, but I'm gonna allow it. What is the purpose of this one? It's for the record, it's 85.
Judge, it's to show that there were no other injuries documented on this portion of his body. The medical examiner has to show that she did a complete and thorough examination of this body and a complete autopsy. And so in order for us to fully develop our case, we want to show that she was thorough in her evaluation and her documentation of the victim.
Does the case law on autopsy photographs, are you telling me it?
Her job is to document all injuries that she notes and any word that she does not note. And yes, in cases that we are having a medical examiner testify, we show full body photographs to show that she did a head to toe examination of the patient and of the victim.
All right, any argument on that one?
Yes, Your Honor. There's no issue of material fact in the areas in which these victims were not injured or shot, and that's something that the medical examiner is more than able to thoroughly explain on direct examination, that through her process, her training, her experience, that they do detailed inspection of the body, and it just serves no purpose to show where he was not shot or injured.
Well, credibility of the witness is always an issue, and it sounds like the state is suggesting that they're using the photograph to support the credibility of the witness's testimony regarding a thorough review of the body and autopsy. So I'll allow it. So as of now, the only one that I've struck is 80, because essentially I think it's a duplicate, and that's why I'm striking it. I'm looking at the other set, which is starts with. That was all of the body in there. That I've looked at. There's some that show different bullet holes. Were you objecting to those that show the bullet holes?
Can I see them, Your Honor?
Yeah. Then there's a bunch of clothing.
He's going to allow all of them except the one.
Yeah, the only one I took out was 80.
Okay, so these were the two you were referencing just now.
Right. That show bullet
Same
holes.
objection as previously, Your Honor.
All right, I'll overrule that objection. I'll allow all those. So out of that stack, the only one I'm removing is 80, and again, that's because I don't think there's anything depicted in it that is not also depicted in a pretty much a duplicate of it, which is zoomed in. Looking at Juan Guitron photos. Same arguments essentially from the defense regarding Juan Guitron.
Yes, Your Honor, and just briefly.
And for the record, they're 89, 90, 91, 92, and 93, and those are state exhibits. Yes, did you want to look at?
Yes, can I see?
Yes. Let me put them back in order. Ms. Johnson, I'll give you this one back, but this is the one that I'm, based on their objection, I'm granting.
Yes, same argument, but I would like to point out specifically Exhibit 89 and Exhibit 90.
Here, hold on.
These two that I
Oh,
read,
yes,
I
okay.
apologize.
Yes.
I understand the court's ruling on the previous photos of the faces as far as the abrasions are concerned. There's no abrasions on that photo. Again, abrasions have nothing to do with the cause of death. They are not here to prove any type of material fact. We would argue that that tubing and everything that's presented in these photos are highly prejudicial, and the state does not require those to prove any material fact that's being disputed.
My only concern, Ms. Johnson, is I recall being presented with a case before. I don't know if the defense, well, I recall being presented with a case before that was reversed because there was medical equipment shown in the autopsy photographs. Are you familiar with that case?
I'm familiar with that case, Judge. I have tried many cases that we have shown how a body was received by the medical examiner, that there was medical intervention used, and that is something that she has to take into consideration when she is in fact examining the victim's body. And in fact, regarding Juan Guitron, one of the wounds is covered up by the suture line, so you can't even see that. So I think it's important to note that she received the body as is, that there was medical intervention, and that that can potentially affect how she views a body and how she comes to her opinion and conclusion.
What is this one? I mean,
And I'm sorry, when you say this one, I don't know. I didn't see the photograph.
It's number 89. And the reason I'm doing this is because there is a bunch of case law that on a 403 argument related to autopsy photographs had reversed, saying that the prejudicial effect outweighed any probative value. What's the probative value of that photograph separate from the probative value of this photograph?
So this photograph has the victim's name, the date the autopsy was done, the case number, and documenting that this in fact is Juan and not Sergio Guitron.
And Your Honor, we've already stipulated to that with a signed stipulation.
But they're not going to know when they're looking at the photographs who is who, technically. None of the other photographs document that that's actually Sergio. That is the only one that documents that this is in fact Juan. We don't have any documentation from the other batch of photographs that that's Sergio. So we included that in order to show that those photographs are regarding Juan, and we didn't even pick another photograph to include in our pile for Sergio.
Your Honor, I would argue that any other photos that are admitted don't have labeling of the items that are being presented either. That is described through the testimony of the witness.
It's a risk, but I'll allow you to take it. I think it's a risk on appellate purposes, but I'll overrule the objection.
Judge, would you like me to pass it the stipulation that we would ask that you read prior to?
Yes, and I'm going to need the stipulation instruction, which, oops. I thought I saw, let me see if I can find it. And please, I'm putting this on you all, please don't let me forget this instruction regarding prior witness testimony when a video is played from the prior trial, I think. So I have that here, and I also have 2.3 stipulations, which I will read. Did the defense need to take a look at? It looks like the standard, it's 3 sentences on stipulations. I will read that right before I read the stipulation.
And Your Honor, I did want to put something just as a heads up that I've already discussed with the state as far as the recorded testimony. It's my understanding that there was evidence from both sides admitted in some, if not all, of the witnesses that are being presented. Just for logistics and continuity, we were discussing how that should be done because the camera view doesn't zoom in on those exhibits every single time, but it's the intention of the defense, and I believe the state too, to admit those same exhibits.
Right.
And just as far as continuity, and just being able to present it to the jurors, I just wanted to bring that to your attention.
Yeah.
I don't think that was just.
I don't foresee a problem. Let me ask you all this: if it's being testified to on the video, but you can't see for whatever reason from the camera angle that was used by whoever was reporting it, do you all want to put up the same exhibits being referred to on the Elmo so that it's being shown?
We would have to stop it, go over to the Elmo.
Oh,
put the
that's
exhibit,
right, because
and
it's
then
on the
go back
same
to
So
screen.
we were talking, I don't know if afterwards if they wanted
Yeah.
to go through them and then we would do the same, or before. I don't personally, I can defer to my co-counsel.
Right.
I personally don't have a preference, but as far as the exhibit.
No, I mean, that sounds like a good idea, and it looks. Ms. Johnson was nodding her head in agreement. So if after you want to put up those exhibits that were referred to on the Elmo so that the jury can see them, I'm all right with that, particularly if you all agree. I don't stand in the way of progress. If the two sides agree, I very rarely, if ever, disallow it. Mr. Grant, was that stipulation...
I showed it to Ms. Hodges. Everything's great. One minor exception is it says in the last sentence, stipulated facts is, it should be are if it's plural, or is. It's just a grammatical
in this
issue.
case, the stipulated facts that you must accept
As true are if it's plural, or is if it's
well, I think it's a right for this, because then I'll read this stipulation. So I think it's to be done for each stipulation.
right. So you can say stipulated fact is, facts
Yeah.
are. However you want to do it,
I appreciate that. I'll try to make it grammatically correct when I do it.
don't get it either way, but I don't want you to get picked on.
I mean, technically, there's two facts in this stipulation. It's one stipulation that includes two facts. So I'll do it in the plural.
However you do it, Judge.
All right.
I was just noting.
I appreciate
the
that.
grammar police may be watching.
I appreciate that. All right. So, other than that, the stipulation, the rest of it, standard language. So my understanding is they're gonna request the stipulation in the presence of the jury before they call the witness. Is that correct?
Before the witness, Judge, yes.
Okay. And so then I'll read the instruction, and then I'll read the stipulation, and then I'll hand the stipulation to the clerk. It'll be in the evidence that goes back.
And Your Honor, as far as the exhibits being posted on the Elmo or whatever, I have no issue. Defense has no issue with state going through their exhibits on the Elmo afterwards, and then if we had any exhibits, just announcing it for the record and showing them on the Elmo, if that's okay with you.
State agree?
Yes, Judge. I don't know, what would Your Honor think if we did it, if we published them before and after, so that they can kind of know what...
I think
Once.
one would be better.
Once.
Okay, that's fine.
All right. Are we ready for the jury now? State ready?
The defense is sorry.
The defense is ready. State ready?
Defense is ready. Yes, sir.
Let's get the jury. Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. Happy Thursday. My first question to you is, was anybody exposed to anything about this case between the time you left the courtroom yesterday and the time you returned, or has anyone discussed this case either amongst themselves or with anyone else by show of hands? Excellent. Let the record reflect that there are no hands. Again, thank you all very much. We are going to pick up now, and I'll ask the state if they are ready to proceed.
Yes, Your Honor, the state would call Dr. Mary Mainland.
All right. Was there anything?
Yes, Judge, are you going to read the stipulation?
Are you requesting that I read the stipulation at this time?
Yes, Judge.
Ladies and gentlemen of the jury, there is a stipulation between the parties. There is an instruction regarding stipulations that I will read to you first, and that is as follows. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are, and I'm going to hold it up and show it to you, then I'm going to read it to you. This is the stipulation to identity, and it'll go into evidence, and you will have it back with you in the jury room. It reads as follows. It is hereby stipulated by and between the state of Florida and the defendant, Michael Keetley, that Sergio Guitron, the person named in count 1 of the incident in this case, died on November 25th, 2010 in Hillsborough County, Florida. Juan Guitron, the person named in count 2 of the indictment in this cause, died on November 25th, 2010 in Hillsborough County, Florida. We hereby certify that the foregoing stipulation is made in good faith and for the reasons herein alleged, dated this 7th day of March 2023. It is then signed by Michael Keetley, defendant, Richard Escobar, attorney for defendant, and Michelle Doherty, assistant state attorney. And that document will go into evidence and will be available to you when you are deliberating.
Now we call Dr. Mary Mainland, Judge.
Dr. Mainland. Dr. Mainland, good morning and welcome. If you'll come forward to be sworn as a witness wherever you're comfortable, if you'll face me and raise your right hand, thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. If you'll follow the bailiff to the ramp, please watch your step. Go ahead, have a seat when you get to the chair. Make yourself comfortable. If you've got reports or anything you need to unpack, you go ahead. You let me know when you're ready. Let me make sure that microphone, the light is on. Yes. Oops.
Seat.
You all right?
The seat is really funky. I feel like I'm going to fall out of it.
I'm
But
sorry
that's
about
okay.
that.
That's okay. I'm ready.
All right. Ms. Johnson, you may proceed.
Good morning, Doctor. Can you please
Morning.
introduce yourself to the jury?
Yeah, my name is Mary Mainland. I am a medical doctor, forensic pathologist by trade.
And are you currently working or employed?
I'm retired.
And how long have you been retired for?
2 years.
And prior to your retirement, what did you do?
I was a forensic pathologist working for the Hillsborough County Medical Examiner Department.
And what position did you hold there prior to your retirement?
At the time I retired, I was the deputy chief medical examiner. I've also held positions of chief medical examiner and associate medical examiner.
And how long were you employed at the Hillsborough County Medical Examiner's office?
12 years.
And where is that office located at?
It's up on 46th Street. It's just across Fowler Avenue from USF.
And what were your duties there as a medical examiner?
Mainly to determine cause and manner of death in cases that are required by law for a medical examiner to investigate. Practically speaking, that means doing a lot of autopsies and a lot of death investigation.
Did you have prior employment prior to working at the Hillsborough County Medical Examiner's Office?
Yes,
And where was that at?
in Wisconsin.
And what position or what type of employment did you have?
I was an assistant medical examiner in Milwaukee County, Wisconsin, for 3.5 years. After that, I took a position of chief medical examiner in Kenosha County, Wisconsin, also for 3.5 years.
Can you give us a brief educational background?
Sure, where would you like me to start?
If you can start with your college degree.
Okay, I received my bachelor's degree from the University of Wisconsin-Milwaukee. That was in Russian language and literature. Following that, after some time, I went back to school, took pre-med courses, applied to medical school. I graduated from medical school in 1995 from the Medical College of Wisconsin in Milwaukee. Following that, I did 5 years of anatomic and clinical pathology residency. And finally, after that, 1 year of specialized study in forensic pathology.
And are you board certified?
Yes, I am. I'm board certified in anatomic, clinical, and forensic pathology.
Can you explain to the jury what forensic pathology is?
Sure. I kind of hinted at it a little bit, but we deal with death. And there are, as I said, there are certain types of deaths that are specified by the state that need to be investigated by, well, in Florida, it's a medical examiner. Some states also use coroners. But our job is to determine the cause of death, and the manner of death. Manner of death is kind of how it happened. And so in that process, we do a lot of investigation. We look at a lot of records. We work with law enforcement, et cetera, et cetera. Ultimately, we end up doing a lot of autopsies or postmortem examinations to help us.
Do you look at injuries as well as possible diseases to ultimately determine the cause of death?
Yes. The cause of death is going to be either a disease or an injury. Forensic pathologists have special training in injury.
And you have mentioned before that there are certain kinds of death per statute where the medical examiner will perform an autopsy. What kinds of deaths are those?
Okay, we can. The easiest way is to go through it by manner. Manner is kind of how the death, the type of death. So there are natural deaths, which is pretty easy, cancer, heart attack, etc. That's easy to picture. There's suicide, everybody knows what that is. There are accidental deaths, there are homicides, and there are even a few that end up being undetermined. So those type of deaths, pretty much anything that has a chance of maybe not being a natural death comes to the medical examiner.
Have you also taught or presented at conferences in the area of forensic pathology?
Yes.
Are you a member of any, or were you a member of any professional associations prior to your retirement?
Yes, I did belong to the National Association of Medical Examiners. I still do attend their meetings.
How many autopsies have you performed, or did you perform prior to your retirement?
Just short of 4,000.
And how many times have you testified in court regarding your work in this area?
Well over 100.
Has a court ever refused to allow you to testify?
No.
Judge, at this time we would ask if the defense has any questions in this limited area.
Any questions?
No, Your Honor.
You may proceed.
Can you explain to the jury how it is that the medical examiner's office is notified of a case that they may need to be involved in?
We'll typically get a notification, either depends on where the death occurred and what type of death, but it'll be either from a hospital or law enforcement. Mostly hospitals and law enforcement, and so they will. They realize which type of deaths need to be reported, and so they will call that death in.
How is it that it gets determined what medical examiner will be assigned to a case or to perform an autopsy?
We just have a rotating schedule. Whoever happens to be on call assumes those duties.
Did you happen to be on call on Thanksgiving Day, November 25th of 2010?
Yes.
And did you ultimately get assigned a case involving brothers, a Sergio Guitron and a Juan Guitron?
Yes.
Do you recall when or how you were notified regarding these cases?
I was probably already at the office because we received the call, I think, a little before 9 o'clock in the morning. And so I would have been told by one of our medical legal death investigators that there was a case and there was a scene investigation that where law enforcement requested my presence.
And I want to take a step back for a moment. Can you explain, we've been using this word autopsy, but can you explain to the jury what an autopsy is?
Yes, an autopsy is a very thorough physical exam. The reason it's so thorough is because it's post-mortem. So the pathologist will look at every single organ in the body. We do that by opening up the body, the chest and the abdomen, removing all the organs, weighing each individual organ, examining it, dissecting it. And we do the same with the head. We remove the brain and actually examine the brain itself. In that process, we're taking some samples to use for toxicology studies, samples to study under the microscope, et cetera, et cetera.
I'm sorry, I didn't mean to interrupt. Go ahead, please.
Yeah, and then in the end, we put it all into a report.
When you say that you collect fluids for possible toxicology, what do you mean by that?
We will collect blood, urine, even fluid from the eyes, bile from the gallbladder, etc. Most of the autopsies done in Hillsborough County are studied also by the toxicologists to look for drugs, poisons, medications, etc. So
that is not part of your role as a medical examiner to test those items. Is that correct?
That's correct.
So when you learned, when you learned of this case on Thanksgiving Day, on November 25th of 2010, and you learned that there are going to be some cases coming to you, do you remain there at the office, or what do you do?
No, I was requested to go to the scene and investigate because there was one deceased person remaining at the scene.
And is that standard procedure for the medical examiner to go out to crime scenes?
Yes, at least at that time it was.
And do you go out to all crime scenes?
No, mostly scenes where a homicide is suspected, or really pretty much anything that the law enforcement or district attorney would request our presence.
Do you go out to scenes when bodies are not still at the scene?
Not typically.
Why is it that you go out to scenes where bodies remain and not scenes where bodies have been removed?
Well, we like to see the body in relation to its surroundings, at as close as possible to the time of death. Just how is the body positioned? Is it warm? Is it cool? Etc. We get a lot of information directly on the scene.
Is that information then that you then utilize in coming to your ultimate opinions regarding cause and manner of death?
Yes.
Where is it that you were asked to respond to?
And let me get the address. It was on Ocean Drive in Ruskin. Hang on one sec. Oh, sorry, Ocean Mist Court, 604 Ocean Mist Court in Ruskin.
Did you have any initial information from law enforcement prior to responding there?
It's kind of fuzzy what came in beforehand and what came afterward, but I recall, being told that there had been a shooting, multiple people had been injured, and that there was one deceased person still remaining at the scene.
Publishing what's already been introduced into evidence is State's Exhibit 6A, and over to your left, Doctor, is a screen that will be showing you the photograph. Is this what you observed upon your arrival at 604 Ocean Mist Court on November 25th of 2010.
Yes.
And publishing 58A, specifically, were you there to observe and briefly look at, not conduct a thorough examination at that time, but to look at the deceased Sergio Guitron? Is that correct?
Yes.
And is this how he was when you had arrived there?
Yes.
State's Exhibit 56. This is a close-up of him. Is this how you observed him upon your arrival?
Yes.
What, if anything, did you note of Mr. Sergio Guitron when you arrived there to observe his body?
Well, the most important finding was the fact that there were two gunshot wounds, one on either side of his chest or back area.
When you arrive on scene to examine a victim, do you touch the body, move the body, anything like that?
Yes. We'll touch as much as we need to. We explore, we look for wounds. We will turn the body over. And we'll also manipulate the body for photographs.
Were there any other victims on scene when you arrived there on that Thanksgiving Day?
No.
Do you recall approximately what time you did respond there to 604 Ocean Mist Court?
I think it was about 9:45 in the morning. I can tell you in a second. That's correct, 9:45 in the morning.
Did you make any other observations of the porch when you were there that you recall?
Just the surroundings, the condition of the body. It was. Excuse me, one sec.
With looking at your notes, refresh your memory.
Yes. The body was cool. It was already going into rigor mortis.
Can you explain what that means to you as a medical examiner when a body is cool and that rigor mortis is setting in?
Okay, that the death had probably occurred more than a few hours earlier.
Did you have, was that consistent with information that you had been provided by law enforcement?
Yes.
Were you aware that this shooting had occurred in the 2 o'clock hour in the morning?
Yes.
And what is rigor mortis?
That's just a stiffening of the muscles after death. It follows kind of a generalized timetable. It takes a while to come on. It peaks at about 12 hours and then it gradually dissipates.
Are there investigators from the medical examiner's office that accompany the doctors to crime scenes?
At this time, no. It was the doctor's responsibility on these homicide scenes.
I'm going to show you State's Exhibit 56A, which is showing some jewelry still on Sergio Guitron. Is that something that you take into consideration when you find a body such as this?
Well, we certainly observe it. We don't remove it. Well, we remove it from the body, but we turn it over to law enforcement.
Okay. What happens once you are there at the scene, you make observations of Sergio Guitron? What happens next?
Make my observations, take photographs, discuss if there's anything to discuss with law enforcement on the scene.
Why is it that you take photographs there?
Just, again, being as close as possible to the time of death, to the condition of the body at the time of death. Because once a body is transported, things can be altered.
And so what happens once you conduct your examination, your observations there at the scene? What happens next?
We have a service that removes the body from the scene and takes it to the medical examiner morgue.
Does the medical examiner's office then take custody of that body at that
Yes.
time? And when you say transfer to the morgue, is that at the medical examiner's office over across from the USF area?
Yes.
And did you conduct an autopsy of Sergio Guitron that day, in fact, on November 25th of 2010?
Yes.
Were you aware at that time whether or not there were any other deceased victims in this case?
I think by the time of the autopsy, I think I knew that there was another,
Another deceased victim?
yes, another who had died at the hospital.
Were you, so the other deceased victim, was that someone who later became known to as Juan Guitron?
Yes,
Were you made aware that those were in fact brothers?
yes,
And ultimately, did you later conduct an autopsy of Juan Guitron the following day?
yes.
I want to stick first with, let's first talk with Sergio Guitron since you conducted his autopsy first on the 25th. Approximately what time did you begin your autopsy on him?
It was, 1 second, about 2 o'clock in the afternoon.
And how do you go about beginning your autopsy? What do you do first?
Well, the first thing we do is we look over the body externally, look over all the surfaces and make notes. Just normal things like hair color, eye color, body type, etc. And we'll note any. Most importantly, we'll note any injuries to the body. So general things and specific things like injuries.
And do you do basically a head-to-toe external examination at that time?
Yes.
And do you document your findings, your observations?
Yes.
And how do you do that?
There are 2 ways. At the time of the observation itself, we diagram what we see, and then after that it gets dictated into a report.
Are there photographs taken of the body prior of your external observations?
Yes.
And you said that you also document them on a diagram. Is that prepared by you?
Yes.
And is that included ultimately in your medical examiner report?
Yes.
Initially, when you made observations of Sergio Guitron, what, if anything, did you observe and note?
The gunshot wounds, there was a gunshot wound. There was a hole, if you will, on the right side of the back, kind of in the deltoid area, and then there was another hole on the left chest area.
May I approach the witness, Judge?
You may.
Dr. Malin, prior to coming here to testify, have you looked at the photographs of Sergio and Juan Guitron of the date of the autopsies, the date the autopsies were performed?
Yes.
And do they fairly and accurately depict photographs that were taken by the medical examiner's office prior to and during their autopsy?
Yes.
Judge, at this time, the state would offer into evidence State's Exhibit 81, 82, 83, 84, 85, 86, 87, and 88.
Anything other than previously discussed? No. They'll be admitted at this time.
Permission to publish, Judge?
You may publish.
Publishing 81. Can you explain to the jury what this ruler with numbers is on? What does that mean?
Yes, that's just for identification purposes. The year is 2010, and the 7181 is the number of the actual case. So that's a unique number to this individual.
And this was Sergio Guitron?
Yes.
And can you explain how he is positioned or where he is at the medical examiner's office?
He's lying on an autopsy table, and he's in the intake area. He's being photographed and examined at this point. I'm sorry.
I'm sorry, I didn't mean to interrupt
Yeah,
you.
we typically take a shot of the head from the front for possible identification purposes later.
Did you note any injuries to the top part of his body?
There's a scrape you can see on his forehead.
Is that over covering his right eyebrow area?
Yes.
Okay. And can you explain how scrapes possibly occur?
A scrape is just it's a type of blunt impact wound. All it is we call it an abrasion, but all it is a scraping motion. So say the head hits something and there's a little bit of friction, or something hits the head one way or another. It could be from a fall, it could be from walking into something, etc.
So if Mr. Guitron had been on his knees and he fell forward and hit his head, is that injury on the abrasion on his face consistent with that?
Yes.
Did you note any other injuries on the top part of his body?
The gunshot wounds that we briefly described.
And we're going to get to those. I'm going to show you State's Exhibit 82. What are we looking at here, Dr. Mainland?
Okay, this is Mr. Guitron's right knee, and you see the large label, and then there's also a little label with the same number on it, and that's just another scraping injury.
Similar as being caused from blunt impact?
Yes.
Publishing States 83. Can you please explain what we're looking at here?
Yes, as you can see, this is the right side of Mr. Guitron. That's his kind of his deltoid area. The arm is kind of lifted up to show the wound better, and the wound there is an entrance gunshot wound.
And is his arm lifted up because that is part of the upper back portion of his body?
Yes.
And you said that you called that an entrance wound. How is it that you know that that is an entrance wound, and what do you mean by that?
Okay, it means it's where the bullet went in. Entrance wounds and exit wounds tend to look differently. They have different appearances. An entrance wound will typically be more round and have more scraping along its borders, etc. And so this one has those characteristics.
Are you able to determine from looking at this entrance wound how far the shooter was from Mr. Guitron at the time that Mr. Guitron suffered this injury?
No, I can say he may have been as much as 3 feet or more away, 1.5 feet to 3 feet.
And what things do you look at to make that determination?
You look around the wound, you look at the skin, and when a gun's fired, other things come out of the muzzle besides the bullet. That would be unburnt gunpowder, burning pieces of gunpowder, and soot. So if we see black soot around the wound, we know that's pretty close. If we see little marks from gunpowder, which we call stippling, we know that's also within a certain range. I see neither of them on this photograph.
So if you were to see those things such as soot or stippling, would you be able to say then that the shooter was less than 2 feet away?
Yes, probably. Again, it follows kind of a range, and it depends on the individual weapon and the type of ammunition, but generally speaking, yes.
Publishing States Exhibit 84. Can you explain what we're looking at here?
Yes, this is right below the left armpit, and this is an exit wound.
So is it fair to say that this injury was a through and through, that it traveled from the right side of Mr. Sergio, or entered into the right side of Mr. Sergio Guitron, and that bullet exited the left side of his body?
Yes, that's correct.
And can you explain how you were able to determine that this, in fact, left side injury, gunshot wound, was an exit wound?
It has a little bit different characteristics. It's not as round. It's kind of more elongated. If you look very closely, you can see some of the fatty tissue kind of like turned out. It's a result of the bullet. When the bullet goes in, it goes in pretty much nose first, but once it strikes things in the body, it tumbles, and so the bullet may have come out of the skin sideways or backwards or whatever, but that's why it looks a little more irregular.
So, did you note any other gunshot wounds to Mr. Sergio Guitron upon your external examination of him?
No.
And so, after you conduct an external examination of a victim, what's the next thing that you then do?
The next step is the internal examination.
And how do you go about doing that?
Okay, as I was kind of describing earlier, we open up, we make what's called a Y incision because it looks like the letter Y. We start at the shoulders, go down to the chest, and then go down the middle of the abdomen. And from that point, we reflect the skin and the muscle. We remove the front of the rib cage so we can access the chest organs. From that point on, we remove and examine each organ individually.
And just to be thorough regarding your head-to-toe examination, I want to briefly go back. Publishing states 85. Is this photograph documenting that you didn't see any other injuries to the back other than the gunshot wounds that you previously described on the upper right portion of his back,
Yes.
exiting out the left side?
Yes.
So you go and you perform an internal examination, as you were stating, and when you do that, since you saw the external entrance and exit wound, are there particular areas of the internal examination that you concentrate on?
Well, certainly we're going to pay a lot of attention to the path of the bullet through the body.
And how do you go about doing that?
By observation. When you open the body up, there may be blood, excess blood that shouldn't be there. There may be damage to the individual organs. There may be fractures, say, of ribs or whatever. We're doing the same thing as we did on the external exam. We're just looking for evidence of injury.
Did this bullet hit any major organs of Sergio Guitron?
Yes.
And what major organs did it hit?
It hit the heart and both lungs.
We had briefly discussed previously that you noted the entrance wound was on the right and the exit wound was on the left. Are you able to determine anything other than that, other than the right to left path of travel of that bullet? Are you able to determine anything else, whether front to back, if it was upward or downward or anything such as that?
Sure. The path was mostly from right to left, but it was, as you could probably tell from the pictures, it was a little bit back to front, so it wasn't, completely 100% straight across. It was a little bit back to front, and then it was a little bit downward.
And is that consistent with the shooter being behind Mr. Sergio Guitron, with the path of travel being from the back of his body to the front of his body?
Yes.
And the fact that the path of travel of that bullet was slightly downward, that the gun position was higher than the position of Sergio Guitron.
Than the position of the entrance wound.
Yes,
in
I
Sergio
apologize.
Guitron.
Is that path of travel consistent with if the shooter was standing and Mr. Sergio Guitron was down on his knees, that path of travel consistent?
Yes.
When you were there at the home, had they removed any of the porch and found any of the projectiles below that porch area where Mr. Sergio Guitron was located?
I don't think they had done that yet. I know they had taken things, they've removed things from the surface of the porch. But I don't recall them having done that. It's possible, though.
Were any of the fluids that you previously discussed, were those collected and ultimately tested?
Yes.
Were there any results that came back regarding toxicology that weighed into your opinion regarding the cause and manner of death of Sergio Guitron?
There were certain results, but they did not change my opinion.
What was your ultimate opinion within a reasonable degree of medical certainty regarding the cause of death of Sergio Guitron?
The cause of death was gunshot wound to chest with perforation of heart, lungs, and pulmonary artery. The pulmonary artery is just an artery that leads off of the heart to the lungs.
And what is your opinion regarding, within a reasonable degree of medical certainty, regarding the manner of death?
Manner of death is homicide.
When you conduct an autopsy, do you also take photographs and document clothing that a victim may arrive in?
Yes.
And did you do that regarding Sergio Guitron?
Yes.
Publishing states 86. What are we looking at here?
Well, there you can see his shirt, a blue striped polo shirt, and you can see some blood soiling on either side. It's been cut by emergency personnel, who were trying to, assess him at the scene. So you can see the shirt. You can see a pair of boxer shorts, and that's about it.
Was it consistent, you finding Mr. Sergio Guitron as you did, was it consistent with emergency medical personnel attempting life-saving measures prior to your arrival?
Yes.
Did you learn that information also from law enforcement, that emergency medical personnel had arrived on scene and had attempted to do that?
Yes.
When you see this blood on his shirt, was that anything that went into your ultimate opinion or that you noted?
It's just, it's consistent with the location of the gunshot wounds on the body.
Is it consistent with having hit those internal organs that you previously testified to, that amount of blood that was on his clothing?
Yes.
Publishing States Exhibit 87. Is this the shirt, the back side of Mr. Guitron's shirt?
Yes.
And I'm zoom in. And I'm pointing to a small area here on the back right side near the seam of the right shoulder area of that shirt. Is that anything that you noted regarding your investigation?
Yes, that's a bullet hole.
And is that consistent with the entrance wound that you observed on Mr. Sergio Guitron?
Yes.
And lastly, States Exhibit 88, do you also document pants, shorts, shoes that the victims are wearing when you conduct your examination?
Yes.
And note whether or not there's any possible red staining or possible red blood when you find?
Yes.
Related to this same case, did you, you stated previously that you had conducted an autopsy of Sergio Guitron's brother, Juan Guitron, is that correct?
Yes.
Was that done the same day or the following day?
That was the following day.
So on Friday, November 26th of 2010?
Yes.
And do you begin your examination as you previously testified, doing a head-to-toe external observation and examination, and then following it up with an internal examination?
Yes.
Did you ever respond to the hospital that Juan Guitron had been taken to?
No.
Generally, as a medical examiner, do you respond to hospitals if that's not, in fact, the crime scene?
Generally, no.
And so when is it that, do you recall when the medical examiner's office took custody of the body of Juan Guitron? Was that Thanksgiving Day, do you recall, or was that the following day when he was
I think it was the same day. If you really are interested, I can look through the case file and tell you exactly when. Let's see. I could be wrong. Of course, I said I could look through and find it very easily. And okay, he was received at the medical examiner's a little after noon on the 25th.
On the
of
25th.
November. Yes.
And were you aware when you, prior to your conducting an autopsy of him, how he had gotten from the crime scene to the hospital, whether he was taken by air or by an ambulance?
I believe he was taken by helicopter.
Judge, may I approach the witness, Judge? Dr. Mainland, have you previously looked at the photographs documenting Juan Guitron?
Yes.
During your autopsy?
Yes.
At this time, Judge State would be introducing into evidence, and do they fairly and accurately depict how you found Juan Guitron on the date of your autopsy on the 26th of November?
Yes.
State offers into evidence numbers 89, 90, 91, 92, and 93 at this time, Judge.
Anything other than previously discussed?
No, I don't.
They'll be admitted.
Permission to publish, Judge.
You may vote.
May I have one moment?
Yeah.
On your during your external examination of Juan Guitron, did you note anything initially?
Yes.
And what is it, if anything, did you note?
Well, there were several gunshot wounds. There was also evidence of medical intervention.
And would these photographs that have previously been introduced assist you in explaining those injuries?
Yes.
Publishing States Exhibit 89. Can you explain again what we're looking at here with the ruler and the number?
Yeah. Again, this is an identification photograph of Mr. Juan Guitron. In this photo, you see his name as well as the unique case number. Again, 10 for the year 2010. And 7182 as the unique number.
And you had stated that he had previously been at the hospital prior to coming to the medical examiner's office, and that you had noted some medical intervention that the hospital had tried to utilize to save his life. Do you see any of that medical intervention here in that photograph?
Yes, you can see on the right side of his mouth there's what we call an endotracheal tube. That's just a tube to assist with breathing.
And when you make these observations that medical personnel had, or medical devices were still left, and that medical personnel had attempted to save his life, is that something that you need to consider and look at ultimately in coming to your final opinion?
Yes.
Can you describe what your observations were and what you were able to see, what other kinds of medical intervention had been performed on Juan Guitron?
Okay, there had been two surgeries. The first surgery was where they opened up his entire abdomen and explored it. They removed a kidney and a spleen, and the spleen, I should say, which were damaged. The second surgery was they cut across his chest and opened that up in order to manually massage his heart and try to get him, to try to stabilize him.
And publishing States Exhibit 90, Are those the two incisions that we see in this photograph on the front side of his body?
Yes.
And are you able to see in this photograph any gunshot wounds?
There's one on the right side of the chest, just above the nipple, just above the suture line.
Would you be able to, I think there is a ruler there, Dr. Mainland, that you can point to the screen where you are referencing. Thank you, Dr. Mainland. Were you able to determine upon noticing that gunshot wound whether that was an entrance wound or an exit wound?
Yes.
And what was it?
This is an exit wound.
And during the medical intervention by the hospital, would you have been informed whether or not any actual projectiles or bullets had been located within his body?
Yes.
Were there any projectiles or bullets that had been located within his body during the medical intervention process by the hospital, to your knowledge?
No.
Is that consistent ultimately with your findings in this case?
Yes.
Publishing States Exhibit 91. What portion of the body are we looking at here of Mr. Guitron?
We're seeing Mr. Guitron's back.
And did you note any injuries to the back of Mr. Guitron?
Yes.
And what did you note?
There were 2 gunshot wounds. One on the kind of on the upper aspect of the back on the right, and then another one on the left on the lower part of the back.
Is the top gunshot wound that I'm pointing to have a small tape ruler just underneath it?
Yes.
And does the second gunshot wound that's towards the center right bottom, another gunshot wound that you noted?
Yes.
Are you able to determine what gunshot wound Mr. Guitron suffered first?
No.
Okay. And were you able to determine, let's start with the gunshot wound that is lower down towards the lower left-hand side of Mr. Guitron's back. Publishing 90, I'm first going to show you again 91. We're going to look at the lower bottom one. Publishing 92, it's a close-up of that gunshot wound. Is that correct?
Yes.
And were you able to determine, looking at that gunshot wound, whether or not that was an entrance or exit wound?
This is an entrance wound.
And did you make that, come to that decision looking at all of the things that you stated you look at when determining whether something is an entrance wound or an exit wound?
Yes.
And were you able to determine, you said that no bullets or projectiles were located within his body, were you able to determine where the exit wound was related to this gunshot wound?
Yes.
Were you able to determine that before conducting an internal examination or after?
After.
And where did you determine this gunshot wound exited Mr. Guitron's body?
This one exited on the right side of the chest in the front.
Is that related to the gunshot wound previously that you pointed to in States Exhibit 90?
Yes.
Okay. So can you describe the path of travel of that gunshot wound from the lower portion of Mr. Guitron's back and exiting out in the upper right portion of Mr. Guitron's chest?
Yes. It went from back to front, from left to right, and upward. Would you like me to include the organs?
So let me stop you there. So you said from back to front. So is that consistent with the shooter being behind Mr. Juan Guitron?
Yes.
And you said it goes from left to right?
Yes,
And is that consistent then with the shooter being to the back left side of Juan Guitron?
yes,
And you stated, was it upward or downward?
upward.
And so when you say that it was upward, basically the bullet traveled from the lower, entered in the lower left back of Mr. Juan Guitron and exited the right chest of his. Is that correct?
Yes,
If Mr. Juan Guitron had been kneeling and falling forward at the time that he had been shot, is that path of travel consistent with that?
yes, could be.
What organs did that bullet hit, if any?
Okay, it damaged the left kidney, the spleen. It just kind of grazed the pancreas, went through the stomach and the liver.
That gunshot wound, taking that alone, in and of itself, is that a fatal gunshot wound?
Yes,
I'd like to move to the second gunshot wound that was in State's Exhibit 91, higher up on the back of Mr. Guitron, towards the center right of his back. Showing a close-up, State's Exhibit 93. Dr. Mainland, did you previously testify that this too was an entrance wound?
yes,
Were you able to determine where the exit wound was related to this entrance wound?
yes.
And where was that?
It was within, the surgeons had cut right through it. It was within the incision that they had made to open his chest. And the reason I know that is, well, number one, because of the path of the damage, but number two, they had actually noted that in the medical record.
And so where did that exit wound, where on Mr. Guitron's body did that bullet exit his body?
It was in the armpit area.
And was that the left or the right armpit area?
That would have been the left armpit area.
So can you explain the path of travel then? And you noted that, are we able to see actually that on State's Exhibit 90, or is that exit wound covered up by the sutures that were performed?
It's obscured by the sutures.
Can you tell the path of travel of this bullet wound that was to the higher portion of Mr. Guitron's back?
Yes, it went from a little bit back to front. It went from right to left and a little bit upward.
And so is this consistent with the shooter being to the back of Juan Guitron?
Yes,
And I'm sorry, did you say the bullet traveled from the upward or downward?
a little bit upward.
And so is that again consistent with Mr. Guitron being on his knees or possibly falling forward and that bullet striking him at that time?
Yes,
Were you able to tell how far away the shooter was from Mr. Juan Guitron?
no,
Is that because you didn't see any stippling or soot?
correct.
Were fluids also collected during Juan Guitron's autopsy?
Yes,
Was there anything that came back regarding his toxicology that affected your ultimate opinion as to his cause and manner of death?
no.
What was your ultimate opinion regarding the cause of death of Mr. Juan Guitron within a reasonable degree of medical certainty?
The cause of death was gunshot wounds to torso with perforation of lung, liver, kidney, and spleen.
And I don't believe I had asked you, did the gunshot wound that was to the higher portion of Mr. Guitron's back, what organs, if any, did that hit?
That damaged the lung.
Looking at that wound in and of itself, was that a fatal gunshot wound?
It could have been.
Within a reasonable degree of medical certainty, what is the manner of death?
Homicide.
May I have a moment, Your Honor? Judge, at this time, the state would pass the witness.
Good morning, doctor.
Good morning.
I want to start because you completed 2 separate autopsies in this case, correct?
Yes.
So I want to start with the first. It was Mr. Sergio Guitron.
Yes.
You arrived on scene on the morning of November 25th, 2010, and that is where you were able to observe Mr. Sergio Guitron.
Correct.
And like you previously testified, the reason that you arrive on scene, it's not every case, correct?
Correct.
But you're able to make observations.
Yes.
One of those observations that you made was that you were able to detect an odor of alcohol coming from the body.
Yes.
And that is something you noted in your report as an observation.
Yes.
And once you arrive to the medical examiner's office, you can make additional notes on what you observe. Is that correct?
Yes.
One of those being soot or stippling. And again, we're starting with Mr. Sergio Guitron. In this case, you did not annotate any soot or stippling.
That's correct.
And you previously testified that that means the firearm could have been anywhere from 3 feet to farther from the body's positioning, correct?
Maybe even a little bit closer, depending again on the weapon and the ammunition.
So there's variables that can change
Correct.
this. And when you're observing and making your notes and completing an autopsy, obviously those variations are not something that you can determine.
No, that's done by testing, ballistic testing.
So ultimately, the positioning is not something that you can testify to,
The
as far as the distance.
exact distance, no.
And for Mr. Juan Guitron, that was the condition that you received the body from the hospital.
Correct.
Again, for Mr. Juan Guitron, no soot or stippling,
Correct.
meaning just as you testified, the distance is indeterminate
Correct.
as far as the firearm's distance from the body.
Correct.
There were some scrapes, I believe, and I'm sorry for bouncing, I'll go back to Mr. Sergio Guitron because I don't believe that you annotated any scrapes on the second autopsy. Is that correct?
That's correct.
So scrapes are a little bit more difficult as far as determining where, when, or how. Correct?
They can be.
So in this case, these scrapes that you noted, obviously you're making a thorough observation, so you're going to annotate when you see scrapes or
Yes.
bruising.
Yes.
In this case, you cannot testify to when or how these specific scrapes came about.
Exactly, no.
You additionally testified to the positioning and the consistency of how the gunman could have been positioned with these 2 individuals. The positioning essentially is indefinite because you were not there, correct?
There are possibilities.
Indefinite possibilities.
Yes, anything's indefinite.
Well, as far as there's a lot of variables in this type of situation as well. Movement, for example.
Correct.
Movement of the 2 individuals or the gunman could
Yes.
potentially affect the travel of the bullet, and you cannot testify as to whether these people were moving, but it's a possibility.
It's a possibility, yes.
Just as it is with any positioning, standing, laying down, sitting, twisting even.
Correct.
And you cannot testify to the specific positioning or how it is. You can just say it's consistent with one, but it could be consistent with all of those as well.
Correct.
If I may have a moment, Your Honor.
Yes.
No further questions. Thank you.
Redirect.
On cross-examination, Dr. Mainland, you were asked about that there are a whole bunch of possibilities and indefinites regarding someone possibly moving and how the positioning of the shooter versus the positioning of the victims. Do you recall just
Yes.
being asked those questions?
Yes.
Were all of the gunshot wounds on Sergio Guitron and Juan Guitron, did all of those entrance wounds, were they on the backs of their bodies?
Yes.
Nothing further, Judge.
May this witness be released by the state
She's released, Judge.
and the defense, or subject to recall?
Release.
Thank you, doctor. You may step down. You may be released as a witness at this time.
Thanks, Your Honor.
You're welcome. Yes, absolutely. Check the Ladies and gentlemen, I have two instructions for you before the next piece of evidence is presented. And first, I'm going to read to you this one that says, prior sworn witness testimony will be played for you, read to you, or referenced during the trial. There may be other lawyers conducting previous hearings or portions of this trial. Please do not be concerned with the type of hearing or age of the case. Instead, focus on the testimony and evidence presented. The next one I have is, members of the jury, you are about to listen to or view an audio-video recording. I believe it is a video. Is that correct? This next one is a video? Video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you listen to and consider this evidence. Is there a number, exhibit number? Yes. Yeah. Ladies and gentlemen, I'm told that you need a break, and that's absolutely fine. So we'll send you on our morning break, and then we'll come back and we'll watch a video. Please not discuss this case amongst yourselves or anyone else. Please not do any research related to the case, and please avoid all reports of the case outside of the jury. All rise outside of the courtroom. All rise for the jury. Jury has exited. Everyone may be seated. All right, just so I make sure we're all on the same page, while it is a court exhibit, we're not going to call it a court exhibit. I'm not going to say court exhibit. So when it goes to the clerk, it'll go with that tag number, but that's never going to be said in front of the jury. You're simply going to announce it as state's presentation of witness of testimony of witness whoever. The thing that we finally didn't conclude, though, was 2 exhibits are actually referenced in this video. What are those numbers?
Numbers 175 through 181. So I would move them into evidence at this time, Judge.
Any
No
objection?
objection.
All right, they will be admitted. And then it's my understanding we agreed upon after the video is played, you're simply going to display and say, this is state's whatever number, states whatever number, states whatever number, and put them up briefly on the Elmo.
And if all of them are shown on camera, then I won't do that,
Oh,
Judge.
okay.
But I don't know that all of them are.
I was going to ask that question. When you wanted them once, was it just those that aren't shown?
Well, it sounds like that's all that they want to do is those that aren't shown.
That's what I was checking.
Yeah.
Yeah.
I haven't seen the video, so I don't know what the camera angles are and everything, but if you're satisfied with its presentation during the video, then yeah, I don't see any need to play it, show that to them again.
Correct.
However, if there's reference to one that's not shown, you're welcome to show it, but we're going to do it one time instead of 2 times.
Yes, Your Honor.
Anything else?
No, I don't believe there's any defense exhibits in this one.
So let me ask the state. This is a 28-minute video. 23 minutes. Did you have another video or a live witness that you were going to call after that?
We have a short video.
Which is a minute and 34 seconds.
And then a live witness.
And then a live witness. All right. Because the plan, I mean, I'm flexible today on when we break for lunch. I don't have a hard break. Tomorrow I do have a hard break at 12 because I have a meeting that I have to attend. But I plan to break, we'll see when we get back. It's almost 10:30 now. Assuming we get started at 10:45, we should be able to get both the videos and perhaps a live witness before the lunch break. So even if I break a few minutes before 12 or up to 12:15, 12:30, that's the target to get them to lunch.
Okay. I'm sorry, what was your hard stop today?
No hard stop today. Tomorrow at noon is a hard stop.
For the rest of the day or just
No, just noon. Just noon. I may, though, depending on where we're at, try to let them out early. I like to, if they've been working hard all week, maybe get them out by 3 o'clock tomorrow. Okay.
Judge, we also have that 9 o'clock Zoom hearing on Mr. Johnson.
Yeah, but it's going to be really short. So don't even worry about that because we don't usually get started even though we say 9.
Yeah, I don't
Yeah.
want to do
Yeah, I I'm told we're still waiting on one juror in the restroom. And is the defense ready?
Yes, Your Honor.
All right. As soon as the jury's ready, we'll. Oh, another one got in line. Uh-oh. Short, long.
I don't think she's very long. Less than an hour.
Okay. Well, we'll still try. I had said hopefully we get started back at 10:45. It's now 10:51, and apparently they are not ready yet. But 23-minute video and then a 1-minute video, that gets us till
Maybe through her direct then.
almost 11:30. That's probably, yeah. We'll break. Yeah.
Well,
Probably after the
Also,
jury.
if this is Miss Bose Flansford, I'm doing the cross. I don't anticipate it to be super long, but we can play it by ear. I just
Yeah,
wanted to give you a
let's see
heads
where
up.
we're at. Absolutely. And I may have you all approach,
Okay.
depending on the time. But I don't mind breaking past 12. But if it's going to go, you think, past 12:30, I'd rather just break in between the direct and the cross.
Yeah, if we approach, I'll shoot you a gauge.
Yep.
Thank you.
Perfect. Thank you.
It's not a witness, so. It is an exhibit.
Okay.
It's the Channel 10 interview, and they're not making me call it Channel 10 record custodian.
So you move it in,
Yes.
and then once it's admitted, you'll play it. Is there a need for the edited?
Judge, I think so, because
Recording?
even though we didn't, I think Ms. Gowdy at the last one had concerns about the news story.
Yeah, I don't mind reading that each time.
That's
Just
fine.
let me know. I've got it right at hand here. So once you move it in, they don't object, and I admit it. I'll read the instruction, and then you can play it.
All right, thank you.
All right, jury in the courtroom.
All members of the jury are present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Same question as always. Anyone discuss the case or exposed to anything about the case during the break? By show of hands. Excellent. Let the record reflect there are no hands. All right. You may recall before the break, I read you 2 instructions that apply to this next piece of evidence. It's going to be a video. I'm going to turn to the state and allow them to announce the name of the witness on the video, and then they're going to play that. It's only about a 23-minute video, and then we're going to try to do a couple of other things before lunch. I promise I won't keep you later than 12:30 at the latest before we break for lunch, but probably well before 12:30 we'll break for lunch. State ready to proceed?
Yes, Your Honor. This time we would present the testimony of Henry Bowes.
Henry Bowes.
Bowes.
Mr. Bowes, what do you do for a living?
I own a body shop since I was 22.
And as part of you owning that body shop, do you paint cars?
Yes.
And have you owned that same business since you were 22?
Well, I had one in Indiana, sold it when I moved down here, and opened up another one down here.
Was it the same type of business?
Yes.
So you were painting cars back in, did you say Indiana?
Yeah.
And you also painted cars once you moved here to Florida?
Yes.
And where is your business located at?
It was located at 12545 44th Street, Clearwater, Florida 33762.
I want to ask you about 2010. Where were you working in 2010?
I'd sold my business in 05 and just peddling at home in my garage.
Okay. And were you still painting cars when you were
Yes.
working at home?
Mm-hmm.
And you would paint cars at your home, is that correct?
Yeah.
Where were you living back in November of 2002?
963 Sunrise Drive, Tarpon Springs.
So out in Tarpon Springs.
Right across from Anderson Lake, or Anderson Park,
Do you know?
Lake Tarpon.
Okay, sorry to interrupt you. Do you know a person by the name of Michael Keetley?
Yes.
How do you know Michael Keetley?
Well, I always bought and sold cars.
And did you ever
I
paint
painted
cars?
a bunch of Corvettes for him, other stuff.
And so you would paint cars for him, is that correct?
Yeah.
Okay. And did you know where Michael Keetley lived back in 2010?
Not really, somewhere. See, I'm from Pinellas. He was in what? Pasco? Or not? I don't know. Pasco? Hillsboro? I don't know.
You didn't know where he lived?
Never been to his house, no.
Because you live in Tarpon Springs and that's located in Pinellas, is that correct?
Yes.
And he would bring his business over to you?
No, just one time. My other shop that I sold, he'd always bring me stuff.
Okay. Is Michael Keetley, is he present in the courtroom today?
I don't see him. Yeah, I do. Right over there in the green shirt.
Okay. Your Honor, may the record reflect has identified the defendant?
The record shall so reflect.
And you said one time, do you remember, was that close to Thanksgiving when you saw him?
Yes.
Was that the Friday after Thanksgiving, November? To leaving. Do you remember what was the date when you saw him?
26, maybe?
Okay. Did you give a sworn statement to a Detective Lugo in this case?
Yes.
And looking at that sworn statement, would that help refresh your recollection as to the date?
It was right after Thanksgiving, almost 26th, 27th. 27th, I want to say.
Would looking at your statement that you had given, would that help refresh your recollection?
Yeah.
Your Honor, may I approach the witness?
Absolutely.
Mr. Rose, I'm going to ask you just to read this, not say anything, but just read it so you can take a look at it. Sir, what was the day that you had seen him?
The 26th.
And was that the day after Thanksgiving?
I believe so. Thanksgiving on the 25th.
And Before you saw him, did he call you on the phone?
Yes.
Can you tell the jury, and have you spoken with him on the phone before?
Well, yeah, years ago, you know.
Did you recognize his voice?
Yeah, yeah.
And did he identify himself as Michael Keetley?
Well, he didn't have to. I
You
knew
recognized
the
his
voice.
What was the purpose of that phone conversation?
He wanted me to two-tone a van for him.
Did you agree to do that?
Yes.
Was there any sort of discussion about paint?
Well, yeah, I told him I didn't have enough paint or clear to do it, so he'd have to pick some up.
Did you tell him where he could get paint, the kind of paint you needed?
Yes, I did.
And where was that?
Well, there was an app they call Genuine Paints. Okay. Now, but back then I think it was something different.
And
On
so,
Overton, okay, west of 66th Street.
and where was that located at?
On Overton, west of 66 on the left. 539-6272 is the phone number.
And did you give him directions on how to get there?
I believe so. Told him where it was, yeah.
And what did he buy at that? What did you need for him in order to paint
Clear,
his vehicle?
activator, some tape, log of paper, and paint.
And what did you instruct him to do? To buy those items and bring them to you?
Yes,
And did he do that on that same day?
yes.
When he called you, did you recognize the phone number that he called you from?
No, I didn't, because I went to call it back later, and kind of sounded like a fax machine, and then I got thinking, might have been a payphone.
Yeah, I caution you not to speculate.
I,
So when you say I got to thinking, it sounds like you speculated.
well, when I called the number,
Objection.
it kind of
Wait,
beat.
just hold on. Let me let her ask you another question. Sorry about that.
Mr. Bose, did a person answer that phone when you called?
No,
Did you hear anything? What did you hear on the phone when you called the phone?
kind of like a fax machine does at first.
Did it make a sound?
Yeah, I had been 10 years, you know, had a different, I don't know, you ever call a fax line by mistake?
Sir, I'm going to ask the questions, okay, I understand. Nobody answered the phone, is that correct?
Right.
Okay. And there wasn't any sort of message or recording, is that correct?
No, there wasn't.
Just made a kind of sound?
Yeah.
All right. And at some point, were you at your home at that time when you received that call?
I believe I was.
And what time did he come and see you at your home?
I'm not sure the exact time. My nephew and I had taken a car back to Florida Auto Exchange in Dunedin. You know, we had to, one guy's got to drive one guy's got to drive another one, a chase car to pick us up, you know.
And you did that after you received that call from Mr. Keetley, is that correct?
Yeah.
Okay. And when you came back, who was at your house?
Mike was sitting out front of the lawn chair.
And did he have a car with him?
He had a blue Ventura van.
And was he doing it, had anything been done to the van before you got there?
Yeah, he pulled the tail lights out and the front headlights.
And is that something that needs to be done in order for you to paint it two-toned?
Well, he did a nice job, yes.
I'm going to show you what's been marked for identification. States Exhibit 176, 175, 177, 178, 179, 180, and 181. So guys, can you just take a look at all those photographs? And you've seen these photographs before, correct?
Yes. That's it. One.
Just look at all of them, and then I'm going to ask you some questions, okay?
Okay.
Do you recognize those photographs?
Yeah.
Okay.
Yes.
And is the van that is depicted in these photographs 175 through 181? does that fairly and accurately depict Michael Keetley's van after you painted it?
Yes.
Your Honor, at this time, we've introduced into evidence States Exhibit 175 through 181. Mr. Bose, can you tell me what you did to the vehicle?
No, we just wrapped it, tape lined everything off, then sanded it and covered it with paper and plastic to keep the overspray from getting everywhere.
I want to go back a little bit. You said that you had to wrap it. How do you wrap the vehicle?
Well, you tape and paper.
Tape and paper it. Okay, and did you do that all around the vehicle?
Yes, you have to. If not, overspray will get on the windows, on the roof, and you can't get it off, really.
Did anyone help you with taping and wrapping the vehicle?
My nephew and Mike helped.
And you said when he was there, the vehicle was all blue. Is that correct?
Yes.
And what part of the vehicle did you paint?
The lower, like the body side moldings down.
I'm going to show you States Exhibit 175. Is that the front of Michael Keetley's vehicle? And you can look up, there's a monitor right in front of you, sir.
Yeah, that's it.
Okay.
Now go to the sides, go to the side of it.
Okay. And right now in this photograph, it's two-tone, is that correct?
Yes.
And this, what color is this right here at the bottom of the,
I don't remember. I'm thinking of BA off of a Ford, which is a gold.
a gold tone color?
Yes.
Okay. And did you, when you painted it, did you paint it yourself or did you have assistance with that?
No, I do paint.
And so you painted this part of the vehicle, it's the lower part of the vehicle, is that correct?
Yes.
And before that, it was all dark blue?
Yeah.
States Exhibit 176, is that the side view of it?
Yep. Now you see the style line right above the body side molding, that's where you break it at.
Okay. Are you talking about this?
Above the molding, right in there, there's a style line. No, below your finger.
No what?
It's got like a little style line, it's called down the side, that's where I break it.
Okay. So again, all of this painting down here, this gold paint on the bottom half of the vehicle is what you painted.
Yes.
States Exhibit 180, is that the other side?
Mm-hmm.
And again, you painted all of this, the lower portion
Yes,
of the vehicle.
The complete bottom, yes.
Okay. Prior to that, that was all navy blue?
Yeah, both sides, bumper to bumper.
Or I'm sorry, dark blue. States Exhibit 181, again, that's the front portion of
Yeah,
the
now
van.
if you look at the color, it matches the interior pretty much. Okay, which is a sandstone, beige, camel, whatever you want to call it.
Okay. And so again, prior to painting this, the lower half of the vehicle, it was all blue, correct?
Yes.
Again, States Exhibit 178. Did you also, so the back of the vehicle,
Yes.
did you paint this as well, that same color?
Yeah, the bumper cover and everything.
Okay. In States Exhibit 178, I'm going to point to, is this the taillight?
Yeah.
Okay, that had already been removed before you started painting, is that
Yeah,
correct?
there's only 2 screws to hold it in.
But you did not remove it, is that correct?
No, Mike was doing the best he could with his left hand.
Okay.
So,
States Exhibit 179. This was also removed, this light in the back of the vehicle.
yes.
Okay. And you can also see that this, again, the bottom portion had been painted, is that correct?
Yes.
And you are the one that painted it the Friday after Thanksgiving.
Yes.
States 177. It's the other side, back of the vehicle. Again, the lower portion is the part that you painted, is that correct?
Yes.
Prior to that, all one color.
Yes.
Before you started painting the vehicle, were there items in the vehicle?
Well, yeah, there was, I don't know, looked like, what do you call it, fast food things?
Did
a
you
little
see-
trash.
Sorry.
See, Mike's just like me. When I had my body shop, I doing Nicholas Finance, Regional Acceptance, Mercury Finance, doing their repos, and he wouldn't lease on the stuff that was in them cars. Okay. So I
Is there-
just figured Mike had just bought the van to resell it. And
I
had two
understand that,
times.
Mr. Bose. Did you see everything that was in the vehicle?
No, I didn't. Anything that's in it, no, I don't pay attention to that on cars.
You certainly didn't take an inventory of everything
No.
that was in that vehicle.
No.
During the course of while he was at your house, did he obtain some trash bags and start
Objection to the leading.
I'll sustain refresh.
Did you see him do anything to the inside of the vehicle?
I didn't, actually. He got up earlier, unwrapped it, and I guess got a couple trash bags. And, but
Objection to what he does.
I'll sustain and instruct the witness not to guess. Testify only to what you know, what you observe, but don't speculate, don't guess.
Did you see any trash bags that were filled at your house when Mr.
Yes.
Keetley was there? Describe what you saw.
pardon?
Describe what you saw. How many what kind of trash bags were
I
there?
don't remember. I'm thinking they were green trash bags, the big ones. And he'd already take them out, put them out by the trash.
Okay, so you saw them out by the trash?
Yeah. I
They
didn't,
had they been there before?
no.
Okay. How many of those big green trash bags did you see out there?
Two, well, when you take paper off the whole van, you're going to have at least half a trash bag, maybe more. A good trash bag.
But you saw trash bags out there, is that correct?
Yeah.
More than one,
Yes, two.
two, and they were full, is that correct?
Objection as to the leading.
I didn't go look, to be honest with you, what was in them.
Well, did they look half full, or empty?
Yeah, 3/4. But like I said, all that paper off the van, that's a big vehicle. Especially when you're covering the whole
But sir,
thing.
you didn't see him remove the paper, is that correct?
Objection, leading.
Sir, did you see what he put into those bags?
No,
You just saw that they were 3/4 full, correct?
yes,
And they were out there by the trash.
yes.
And did you tell law enforcement about those trash bags?
I believe I did.
You made it a point to tell him about the trash bags, correct?
Well, no, he was questioning me.
Try not to redo it.
Yes. He was asking me questions, and I told him what transpired.
Sir, did he pay you for painting that vehicle?
Yes,
How did he pay you?
cash, like you always did.
How much did you charge him for painting the vehicle?
I really don't remember. 150, maybe 200.
How long does it take for paint to dry?
It depends on the temperature. I didn't start painting that car till about midnight or so. Or got done about midnight. There's no way we could unwrap it, so he slept on the couch in the living room.
Slept on the couch and waited for it, correct?
Yes.
And you were painting that late into the night, is that correct?
Yeah, I got done around midnight. And it has to dry for 4 to 8 hours, depending on the temperature.
Was there more than just one coat on the car?
What do you mean?
Wait, hold on.
Just on our thing.
Yeah, if you could speak a little, the microphone amplifies your voice, so we're gonna need to make sure that you're close enough to the microphone. Thank you, let us know if you can't hear.
Was there more than one coat of paint on the car?
Well, when you do a base coat clear, you gotta go around you're covering a dark color with a light color. You're gonna have to go around at least 3-4 times to get coverage. And then you gotta go back around 2 more times after that dries and put 2 coats of clear on. So it's a good 3-hour process.
Just to paint it, correct?
Yeah.
With several coats?
Yes.
Okay, and can that affect the amount of time that the car is supposed to dry?
Well, your last coats, your clear is what's gonna dry. The base dries not within 15 minutes. You wait 15 minutes between each coat. Okay, then when you go to clear it, 15 minutes after you put your last coat of color on it, you go on with a coat and let it sit 15, 20 minutes, and then go back again. And then that's going to sit for 4 to 6 hours, 8 hours sometimes.
Sometimes 8 hours.
Yeah.
And you didn't finish until around midnight, is that
Right,
correct?
right.
Okay. And did you say Mr. Keetley spent the night there?
Yes,
Did you see him the next day?
yes.
What was he doing the next day?
Well, he was up working on the van.
Okay. And when you say he was working on the van, what does that mean?
He was unwrapping, taking all the paper off of it. And,
So he did that by himself?
yeah, that's easy.
Okay. He was able to walk around the van, is that correct?
Objection as to the leading.
Sustain refresh.
What did you observe him do?
Well, he was putting taillights back in, which was simple, you know, and he done wrapped it. You know, it's,
So you put the taillights, so you put any other parts back on the
I
vehicle?
believe 2 headlights.
The materials that he brought over, the paint and the clear coat, what happened to that?
Well, we used all the, I think he only got a quart for a clear and a pint of activator, and that's plenty to do that. And once you put the hardener in the clear, you got to throw the other away, the leftover. The paint, I don't remember what he got, a quart. He left the paper and what tape, that was it. Paper and tape was left over.
And so I want to ask you this. So you saw him that Friday after Thanksgiving. When had you seen him before that day? When was the last time you had seen him?
I don't know, I want to say around 08 maybe.
It had been that long since you had seen him?
Yeah.
2008?
Yeah.
Were you aware that he had been shot?
Yes, my wife worked at Tampa General, and I found out through a friend of mine, Kevin Kwasinski, so I asked my wife to stop and see him.
But you had not seen him since then. Is that correct?
No.
And in fact, you think the last time you saw him was 2008?
Yes.
Your Honor, may I have one moment? Yes. I want to go back to that phone call that he made for you to, when he called you to paint the car. That was made on the same day the car was painted, is that correct?
I believe so, yes.
At some point, did he need to make a phone call while he was at your house?
Yes, he did.
And did he make that phone call at your house?
No, we don't have a landline.
Okay. Did you offer for him to use your phone?
I offered him my cell phone.
Okay. And what about your nephew?
I believe my nephew did too.
Did he want to use your cell phone?
No, he said he'd rather go down and use a payphone. So my nephew took him down there.
And when did that occur?
I don't remember the time. A couple hours after he got there, maybe an hour after he got there.
But he had to be driven there, is that correct?
Yeah, because his van had no headlights and taillights.
I have nothing further, Your Honor.
Good afternoon, Mr. Bose.
Afternoon.
Mr. Bose, let me pick up where we just left off. When the three of you went to the convenience store,
No, not I. My nephew and Mike.
and they were picking up also some Gatorades and drinks, since you were going to be working on the van and, painting as you did until midnight,
I
correct?
think, that part I don't remember.
Okay, fair enough. Mr. Keetley, when you saw him on this particular day, he could barely use his right arm.
I know
correct?
that. Mm-hmm.
Is that true, sir?
Yes.
And he could use his left arm a little better, but not much better.
Well, yeah, when you're right-handed, you.
Right. And you noticed that when he was there,
Yes.
correct? Now, I think you said that putting in taillights and headlights are easy.
Yeah.
Okay, somebody has some use of one hand can put it in and then use the screwdriver or whatever.
Yeah, I've had to do that myself.
You can do
when
it
I broke
yourself.
my arm, okay, I'd lean up against the part and hold it in there and use my left hand to put screws and stuff in.
Okay. And I think, and I just want to make clear, you had known Michael Keetley for a long time,
Yes.
because he used to buy and sell cars.
Right.
And that's how you all knew each other, and you painted cars before for him in the past.
Yes.
And he always paid you cash.
Yes.
If I could have 1 second, Your Honor.
Yeah.
No, Your Honor.
May you be excused by the state
Yes, sir.
and by the defense.
Yes, sir.
Thank you, sir. You may step down. You may be excused as a witness at this time.
Thank you.
Did the state have an exhibit now?
Yes, Judge, at this time, the state would introduce state exhibit number 191.
Any objection?
190, Judge, I apologize, 194.
194? All right, there was no objection, correct?
No objection.
194 will be admitted. Oh, and before you play it for the jury, I'm just going to reread the edited instruction. Members of jury, you are about to listen to an audio recording, is this audio or video? Both? Audio, video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you listen to and consider this evidence. You may publish it.
Ice cream truck, so popular in South Hillsborough, is parked. The driver's seat stained with blood, and its owner, Mike Keetley,
You can see the bullet hole.
well, he's grateful to be alive after being shot 5 times.
I didn't see it coming.
About 2 weeks ago, Keetley was driving through this neighborhood when a young woman flagged him down. He thought she wanted a cold treat, but what happened next was chilling.
She was just smiling, happy as everything was fine. Took 2 steps back. Next thing you know, I got a guy with a gun in my face.
2 masked men robbed Keetley of all he had, a couple of books. But they didn't just leave.
Just boom, 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 boom. And every time my heart would beat, I'd just see blood just shooting out.
With blood just pumping out of him, Mike needed help and fast, but he couldn't use his hands to get his phone. So somehow he managed to drive down the road and find a family.
He's the only one we buy from.
Some of Keetley's regular customers helped save his life.
Up to there. That's about as high as I can get it.
Keetley's road to recovery will be long, his future uncertain, but he knows one thing.
They're absolute scum.
He wants this violent gang caught.
And if they were so brazen to shoot me like this over $12, they're going to just kill anybody. They don't care now.
In Hillsborough County, Catherine Bursch, 10 Connects.
All right, I'll ask for the state. Please call your next witness.
Statement called Carrie Bose Flansburgh.
I'm sorry, what is the last name? Well, is it hyphenated?
Yes, Judge. Can you approach?
You need to approach?
Yes.
Sure.
Carrie Bose Flansburgh, Judge.
Ms. Bose Flansburgh, welcome. Is it hyphenated Bose Flansburgh or is it Flansburgh? How do you...
It's Flansburgh now.
Flansburgh. All right, welcome. If you'll raise your right hand, please, to be sworn as a witness. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, if you'll follow this bailiff to the ramp that leads to the witness chair, please watch your step, ma'am. You go ahead and have a seat, make yourself comfortable. That microphone in front of you is fully adjusted. You may proceed.
Thank you, Your Honor. Ms. Flansburgh, can you please state your first and your last name and spell your last name, please?
It's Carrie Flansburgh, Flansburg.
And how are you currently employed?
I work for LCS, which is Freedom Plaza in Sun City Center. It's an independent living community.
And how long have you been doing that for?
I started back in 2018. I left back in August when we moved to New York, and then I just recently came back.
And are you in the process of moving back to Florida from New York?
Yes.
Okay. I'm going to draw your attention back to 2010. Were you married? Were you married back then?
Yes.
And who were you married to?
Henry Bose.
And are you currently married to him?
No, I'm married to David Flansburgh.
And how long were you married to Henry Bose?
Approximately 16 years.
Okay. And when were you married?
We were married in 1997.
Okay. And were you employed back in 2010?
Yes, I was.
Were you doing the same thing that you're doing now or something different?
I worked at Tampa General Hospital, but it was the same job, a manager in housekeeping.
And how long did you work at Tampa General Hospital for?
Approximately 14 years.
Back in when you were married to Henry Bose, what was his employment?
He had an auto body and paint business.
And what was the name of that business?
Beautiful Bodies, Inc. Beautiful Bodies of Clearwater Incorporated, sorry.
Where was that business?
Well, it used to be over off of Ulmerton Road in Clearwater, close to the Sunshine Speedway. But when things went bad with the business, it was moved to our home.
And so back in November of 2010, was Mr. Bose running his business out of your home?
Yes.
And where was your home?
It was in Tarpon Springs.
Did you assist him at all with his business?
Sometimes I did.
What would you do, if anything?
I did bookkeeping. I helped with estimates. Sometimes I would help sand a car or tape it up.
Can you describe what you have to do when you sand a car?
If there's oil on the car, that has to be washed off. But if there's no oil, if it's just dirt, we could sand that with a sanding machine called a DA. But we would have to tape up the car, tape up the windows. Sometimes, depending on the job, sometimes the lights, headlights, taillights would be removed. Moldings are usually taped up.
And the sanding, is that a handheld sander?
Yes.
Were you ever involved in any of the painting of the vehicles when you assisted Mr. Bose?
I never painted a car.
Did you make observations of Mr. Bose painting cars?
I did.
Do you know a Michael Keetley?
Yes.
Do you see him here in the courtroom?
Yes.
Can you please point to him and describe an article of clothing that he's wearing?
He's wearing a dark sweater with a collared shirt.
Please let the record reflect she has identified the defendant. At some point in 2010, when you were working at Tampa General Hospital, did you visit the defendant?
I did.
Can you tell me how that came to be?
Henry had called me when I was working and told me that Michael had been in an accident and he was in the rehab building and asked me to go see him and see how he was doing.
Did you in fact do that?
I did.
Did you visit the defendant more than one time?
Twice.
And let's talk about the first time that you visited the defendant in the hospital. Was that in a hospital room or somewhere else?
It was in a private room in the rehab facility.
And what was the purpose of visiting him?
Henry asked me to go see him to see how he was doing.
And did you do that?
I did.
How long did you stay and visit?
Oh, I don't think I was in the room more than 10 minutes.
And then did you visit him any further?
I saw him one more time in the rehab, the first floor of the rehab building where they actually do the rehab, where they do exercises and stuff like that.
And approximately how long was that visit?
Maybe 10, 15 minutes tops, no more than that.
And what was the point of that visit?
Henry asked me to go see him.
Back in November of 2010, so we're going to jump forward approximately 11 months. Were you living in Tarpon Springs still?
Yes.
Was Henry running his business out of your home at that time?
Yes.
Would customers bring their vehicles to be painted to your home?
Yes.
Was there an agreement that you had with Mr. Bose when customers were going to be bringing vehicles to your home to be painted, that you were going to be made aware of that?
Yes.
Why did you want that to happen?
Because that's where our home was. We had a daughter. We had an 8-year-old daughter. So I wanted to be aware of who was coming, when, in case she was home from school, or just the communication needed to be there.
Between early 2010, when you saw the defendant at Tampa General Hospital, did you see him any time in between early 2010 to November of 2010?
No.
Was there a time, specifically November 26th of 2010, the day after Thanksgiving, that you saw Michael Keetley again?
It was in the afternoon.
And where was that you saw the defendant?
He came to our home.
In Tarpon Springs?
Yes.
Were you expecting him that day?
I was not.
How did he arrive at your home?
He was driving a vehicle and he knocked on the door.
Do you recall what that vehicle looked like?
It was a small van. Thank you.
Publishing.
Okay, sorry.
No, you're fine. Publishing states 177. There's a screen over to your left there. Is this the van that the defendant arrived in on the Friday following Thanksgiving Day?
Yes.
Was Henry Bose home when the defendant arrived?
No, he was not.
And did you speak with the defendant when he arrived at your home?
Yes. I asked him what he was doing there, and he said that he was coming over to have Henry paint his van.
And did you call Henry after that?
I did.
Okay. After, without telling me what Mr. Bose said,
Okay.
Did you allow the defendant to remain at your home?
Yes.
At some point, did Henry return home?
Yes.
Do you recall approximately how long you were there at the home with the defendant before Henry Bose returned home?
Approximately an hour.
Did you have conversation with the defendant while he was there for approximately that 1 hour?
I did.
What did the defendant do while he was there during that hour?
He cleaned his van.
Did you assist him in doing that in any way?
No.
When you say that he cleaned his van, did he clean the outside of his van or the inside of his van?
The inside.
And what do you mean by he cleaned the inside of his van?
He removed some trash.
Did you provide him any items in order for him to put this trash in?
Just some trash bags.
And did you watch him do this?
I sat out there with him, just talking to him.
Did you see what he was putting in these trash bags?
No.
Had you seen customers arrive previously when they would bring cars to be painted?
Yes.
Is it a required procedure to clean out the inside of your car before a paint job is done?
No.
Did you assist the defendant in any way when he was cleaning out the inside of his vehicle?
No.
Do you recall approximately how many trash bags he used to clean out the inside of his vehicle?
2 large black bags and a couple of smaller bags, like from Publix.
Did you assist him in transporting these trash bags and other bags from his vehicle to where you keep your trash at your house?
No.
Objection, Your Honor, can we approach?
Yes.
Where was the defendant's vehicle when he was cleaning out the inside of his car?
The driveway.
And where were you when he was doing this?
Just sitting there.
Were you outside of your home?
Yes.
And did he utilize one hand, or did you make any observations of what hands he was using when he was cleaning out the inside of his vehicle?
Well, I noticed he would have to grab something with his left hand and just kind of place it on his right hand to kind of move it.
And did he ever carry two items at one time?
Only if he could pick it up with his left hand.
Okay. And did he put items in his right hand?
Yes.
And did he carry it with his right hand?
Yes.
Did you see him grab items from the vehicle?
Yes.
And these two heavy trash bags, were those carried? Where did you keep your trash?
Next to the house, right outside the garage door.
Okay. When you saw him cleaning out of his car and removing bags from his vehicle, did you ever have to see him manipulate his fingers around an item and move each digit around a particular item to grasp it?
No.
Did you ever have to see him remove each digit from around an item to ungrasp it?
No.
Did you see he did utilize his left hand more than his right hand?
Yes.
Did you see him use both hands while you were watching him during this time?
Yes.
Before a vehicle is painted, do the headlights and taillights have to be removed?
Sometimes Henry would do that.
And how are these items removed?
If it's depending on the vehicle, there's usually a paneling that goes over the taillight, and the paneling comes off, and then you just remove the screws, or it's clipped. It has a clip. It just clips in.
Do you recall how the defendant's taillights or headlights were attached?
I don't recall that. I'm sorry.
And typically when customers would come drop their car off, you said typically that's something that Henry Bose would do?
Yes.
When people would typically drop their cars off for Mr. Bose to paint, would they remain at your home and wait for their car to be sanded, painted, and unwrapped while it dries?
No.
How would that typically happen?
Usually the arrangements are made a couple days in advance, not knowing what he has going on. They would drop the car off. They usually have a ride.
Objection, Your Honor, speculation.
Don't guess, only testify to specific if you things you observed or know.
Okay. I would see people drop their cars off and they would leave, and they would come back a couple days later to pick up the car.
Was that done with Michael Keetley's vehicle on this date?
No.
You said that you had seen the defendant clean trash out of his vehicle. Did he clean the inside, wipe it down, or anything like that?
Yes.
Did Michael Keetley do anything else that you observed to the outside of his vehicle prior to Henry Bose returning to your home?
No.
Did Michael Keetley ever wash the outside of his vehicle?
At some point, I do believe yes.
Do you recall if washing the outside of the vehicle was done before the paint job or after?
I believe it was done before.
Was that something that was done when Henry Bose was present or was not present?
I don't recall, I'm sorry.
Did you provide the defendant with any cleaning products?
I did.
What did you provide him with?
Dawn dish soap and some rags.
Did the defendant wash his car? the outside of his car?
Objection asked and answered.
I believe so. Let's sustain that.
Did you speak to the defendant about the incident that had taken place in January of 2010?
Yes.
And what did he tell you?
He had stated to me that he was unhappy with the outcome. His right hand, he wasn't able to use it really well. He talked about his limp, the damage he had to his leg, and he wasn't too happy about it. He stated that he wanted them to feel the pain that he had felt.
Did he say how he would be able to accomplish that, making the individuals feel the pain that he had felt?
No, he did not.
Did he describe for you these individuals that had committed the robbery?
He had told me that there was 2 black males and 1 black female.
Did he ever tell you that Hispanics were involved?
No.
And this conversation that you had with him, was this the day he was there to have his car painted on November 26th of
Yes.
2010?
Yes, I'm sorry.
Did the defendant assist Henry Bowes in preparing the car to be painted?
Yes.
Did the defendant assist Henry Bowes in sanding the car?
Yes.
Did you observe the defendant sand his vehicle?
Yes.
Did the defendant assist Henry Bowes in taping up the vehicle?
Yes.
Typically, are the black paneling on vehicles, do those have to be removed or taped up prior to being painted?
Taped up.
And did the defendant assist Henry Bowes in doing that?
I don't recall if he helped to tape up the black moldings.
Do you recall how long it took Henry Bowes and the defendant to complete this paint job?
All evening.
Do you recall what time they finished working on the vehicle?
I went to bed at some point in time and woke up at 2 a.m. and they were still working on the car.
Did you do anything at that time when you made that observation?
Well, I was upset. I didn't do anything except for Henry told me to get him a blanket and a pillow to stay on the couch.
And when you say get him a blanket and pillow to stay on the couch, was that for Michael Keetley?
Yes.
So the defendant was going to sleep on your couch?
Yes.
Is that what he in fact did?
Yes.
Had you ever had a customer before stay at your home when they were getting their vehicle painted?
No.
Did Henry Bowes typically work until 2 or 2:30 in the morning when he would paint customers' vehicles?
No.
Was the defendant still at your home the next day?
Yes.
Was his vehicle done being painted and dried the following day, Saturday, November 27th of 2010?
Yes.
Was the job that Henry Bowes performed, was it to two-tone the vehicle that was once all one color?
Yes.
Was his job to make it this tan color on the bottom portion of the vehicle?
Yes.
Judge, may I have a moment?
Yes. Cross-examination.
Yes, Your Honor.
Good morning, Ms. Landsberg. Do you recall what year it was that you came to know Mr. Keetley? The first time you met him or heard of him?
A year before Henry and I got married, so 1996 possibly.
So you've known Mr. Keetley since at least the mid to late 90s, correct?
Yes.
And I know you just testified to customers coming to the home that obviously there was a change in procedure because it was your home, right?
Yes.
However, Mr. Keetley at this point wasn't a regular customer. You've known him now since the mid to late 90s. This is 2010, right?
Yes.
And you yourself were involved in the auto world as far as the sanding, detailing. You said you never painted, but you're familiar with the process.
Yes.
And you're also familiar that two-toning a van, I don't know about now, maybe at least back then, it increases the value of the vehicle.
A little. Yes.
But it's an increase.
Yes.
Mr. Keetley came to your house that time sometime in the afternoon?
Yes.
And you were living in Tarpon Springs, correct?
Yes.
Were you familiar that Mr. Keetley was living in Ruskin at this time?
No.
But he arrived in that blue vehicle.
Yes.
Therefore, he had to drive from wherever he was, Ruskin, and it was in the afternoon, to your home in Tarpon Springs.
Yes.
You indicated that you yourself were not expecting Mr. Keetley. However, your then husband, Mr. Bose, was, correct?
That is correct.
You learned Mr. Keetley was there to get the vehicle two-toned for his father.
Yes.
And while Mr. Keetley was waiting for your then husband, am I saying Mr. Bose? Am I saying that correct?
Yes.
Bose? I'm sorry.
It's okay.
Mr. Bose, while he was waiting for Mr. Bose to arrive, he said, go ahead, wash it. The vehicle, correct? The outside of the vehicle.
Yes.
And the reason for, and I'm not as familiar with this process as you probably are, but the reason for washing a vehicle on the outside that you're about to paint, or in this case two-tone, is because you don't want dust, bugs, pollen to get stuck under the paint. Is that correct?
That's all sanded off with the sander.
All right, and then cleaning it obviously takes care of it as well.
It does, but not necessary.
And the sanding happened as well.
The sanding happens as well, yes.
You also indicated Mr. Keetley cleaned the inside of the van. Is that correct?
Yes.
I believe that the prosecutor mentioned heavy trash bags. However, you don't know how heavy they were.
I don't know. They were big black trash bags.
Because you weren't really able to see what was being taken out from within the vehicle, correct?
That is correct.
And again, this is happening while Mr. Keetley is waiting for your then husband, Mr. Bose.
That's correct.
And correct me if I'm wrong, this is when you start talking to Mr. Keetley about when he was robbed and shot, right?
That's correct.
And on this day, it's November 26th, he describes that it was one black female and two black males.
That's correct.
Never mentioned the name Juan Guitron.
No.
Sergio Guitron.
No.
Magic or Spider.
No.
Jose Rodriguez.
No.
Daniel Beltran.
No.
Ramon or Jay Galon.
No.
Richard Cantu.
No.
Or Gonzalo Guevara.
No, I've never heard those names before.
And I know you indicated that Mr. Keetley said something along the lines of wanted to feel the pain that he felt. However, that's not exactly the words he used, right?
That's the words that I recall him using.
Do you recall speaking to a detective about this case and having a recorded interview?
The very first time.
And I'll tell you right now when that was. Back on October 8th. Oh, let me go back. I apologize. It was December 4th, 2010. Does that ring a bell?
Maybe. I don't remember dates very well.
I understand. And obviously it would have been after this time that you were with Mr. Keetley, which was November 26th, right?
I guess about. I don't remember the dates.
Well, you're talking to this detective about things that you observed and saw with Mr. Keetley on that date of November 26th. So after, in this case, December 4th. And you were placed under oath to tell the truth, just like today, correct?
Yes, I was.
And I'm pointing to page 2 of 6, second to last line, where Detective Lugo asks you, this is what he told you the day after Thanksgiving. Your response, yes. He said that he would like to see something happen to them because of the way that he was left. Not to have the use of his right hand or his right arm, with a limp in his leg. He said they had to take his bone out of his hip to rebuild his hand. So he has a permanent limp, and he had mentioned to me up until 6 months ago that his mother wanted to put him in a nursing home because he couldn't take care of himself or anything, and he is currently residing with his mother and father. And that was your testimony to Detective Lugo on that day, right?
Yes.
Judge, may we approach?
Yes.
And now I'm going back in time, just so we know what we're talking about. So you indicated when you spoke on direct examination that you visited Mr. Keetley 2 separate times at the hospital, correct?
Yes.
And this was at the direction of Mr. Bose requesting you to do it because Mr. Keetley was a friend of Mr. Bose.
Yes.
And do you remember the time frame of what the month was that you saw on either of those occasions?
I don't remember the month. I'm sorry.
That's okay. But when you were there and you were able to observe him, he was still in the hospital. At one point, you mentioned 2 different times it was rehab, but one was more occupational where he was working with somebody. Is that correct?
The first time I saw him, he was actually in his room, his private room in rehab, which is a different floor. And then the second time I saw him was on the first floor of rehab, where it's a gym where all the patients go to do their therapy or exercises, whatever the patient's having done. It's in that specific area.
Okay, and so that second time was in that specific like gym-like area. Is that correct?
Yes.
That's where you saw Mr. Keetley having some difficulties maneuvering on his own.
Yes.
I think at that point he was trying to learn how to take steps. Is that correct?
Yes.
Was using a wheelchair and assistance from the therapists that were there.
Yes.
And on the date that you saw him next was November 26th. This was months later. At least, do you remember when it was that you stopped working at that hospital?
I stopped working at the hospital in October of 2018.
2018? Is that what you said?
Mm-hmm. Yes.
That same hospital?
Yes.
So, okay, so then the time frame won't help us if it was that long of a time period. I'm trying to think how many months it could have been.
Oh.
At least several months.
Yes.
Was between the therapy session that you observed and when you saw him at your home.
Yes.
And again, you were able to observe that Mr. Keetley was still suffering from the gunshot wounds.
Yes.
he was walking with a pronounced limp.
Yes.
You described it as it's not somebody necessarily dragging their foot, but almost in an effort to bring the leg forward with his body because his knee isn't bending correctly.
Correct. I observed he was wearing shorts, so his leg was more straight, where he had to literally kind of pick his leg up to walk. He couldn't. It wasn't like a normal walk. Like his knee wasn't bending.
And therefore, it was a clear, permanent limp from your observations.
Yes.
You also testified to watching Mr. Keetley while he's maneuvering around the vehicle, picking items up with his left hand and placing them into his right hand, almost like a shelf is the way that I'm trying to describe it for the record. It was almost like a shelf, correct?
Yes.
So if he was picking up items, it was primarily grabbing with the left hand.
Yes.
Correct? And while he may have been carrying around things with his right hand, again, like a shelf, lighter objects.
Yes.
You indicated Mr. Bose and Mr. Keetley worked into the night, and Mr. Keetley ended up sleeping over at your house. Is that correct?
Yes.
His condition was such a concern because of his hand, his leg. Neither you nor Mr. Bose wanted him leaving that evening and driving late into the night because of his condition, correct?
It was a discussion that Henry and I had, yes.
And you decided ultimately it was safer for him to stay and spend the night?
Yes, that was also a discussion that we had.
If I may have a moment, Your Honor?
Absolutely.
A couple more questions. Sure. I asked you about the first time that you met and got to know who Mr. Keetley was. You indicated mid to late 90s, and that was because that was around the time you and Mr. Bose got married.
Yes, Henry and I were dating in 1994, 95, and it was in the time frame when Henry and I were dating is when I met Michael.
And so, therefore, Mr. Bose was more of a friend with Mr. Keetley than you were. Is that correct?
That is correct.
So, Mr. Bose, I don't know if you can tell me how long he had known him, but clearly, prior to meeting you, Mr. Bose was friends with Mr. Keetley.
I would say yes.
At least before the wedding, because at that point, he was the one that introduced you, he being Mr. Bose, was the one that introduced you to Mr. Keetley.
Yes.
One more moment, Your Honor. No other questions. Thank you.
Sure.
Redirect.
Yes, Your Honor. Ms. Flansburgh, on direct examination, you had testified that the defendant had told you that he wanted to make the people that injured him feel the way he felt. That's what you said on direct examination. Is that correct?
Yes.
And then on cross-examination, defense counsel read a portion of your transcribed statement that you made to Detective Lugo.
Yes.
Do you recall that?
Yes.
And she had read a statement portion regarding some of the injuries that the defendant had suffered from.
Yes.
And do you recall what specific words you utilized with Detective Lugo just a few seconds after those words that defense counsel read to you regarding what the defendant said he wanted to do to the people?
I want to get revenge.
Nothing further, Judge. Your Honor, recross.
I will allow recross. On that limited subject.
Yes, Your Honor. I know I previously brought up an interview that you took with a Detective Lugo. Do you recall also taking a deposition at the state attorney's office in which there was a state attorney present, defense attorney, and you were placed under oath again to tell the truth just like today?
Yes.
This was on September 21st, 2011. So obviously much closer in time to when you were discussing these issues and experiencing these issues than we are today. Is that correct?
Yes.
I'm pointing to page 55 and page 56, starting at line 20 on 55. You are asked, okay, and so did Michael Keetley ever tell you that he was going to shoot anybody? You answered no.
Judge, I'm going to object. This is improper impeachment.
Sustained.
Your Honor, may we approach?
You may approach.
So I'll go back a step. You just testified that when you spoke with Detective Lugo, you said that Mr. Keetley wanted revenge, correct?
Yes.
However, you don't know what revenge meant at that time, correct?
That is correct.
Revenge could mean, I want these people arrested, right?
That is correct.
Revenge means, I want these people charged with a crime committed against me, right?
Yes.
It means, I want these people to go to prison.
Objection, Judge. Speculation.
Yeah, I'll sustain
No other questions. Thank you.
that. May this witness be read the direct?
No, Judge.
May this witness be released by the state
Yes, Your Honor.
and by the defense, released or subject to recall?
Subject to recall, Your Honor.
All right, you may step down. You don't have to remain outside, but you are subject to recall. They'll call and let you know if they need you to come back another day. All right, thank you. Ladies and gentlemen of the jury, we are going to take our lunch break. It's 12:02. I'll give you to 1:20. So a little more than an hour and 15 minutes. We've been given about an hour and 15 minutes. That should be sufficient. Has that been enough time for you all for lunch? Plenty? All right. So we'll come back at 1:20. Please not discuss the case amongst yourselves or with anyone else. Please not do any research related to the case, and avoid all reports of the case outside of the courtroom. All rise for the jury. Jury has exited. Everyone may be seated. Was there anything we had to take up during the lunch?
I think we probably do for the next witness, because that's my witness. And
No, I think that's mine, right?
We have Robert Durr, and then we've got David Beckwith. Mr. Escobar's talking about David Beckwith.
David Beckwith. Whenever we get to David Beckwith, we're probably going to have 15, 20 minutes of argument concerning certain issues.
Well, I prefer to do that during the time they're at lunch rather than
Whatever you'd
bring
like.
them back.
Whatever you'd like.
Well, why don't you tell me now what you think the
Well, I've been
preview
given-
is going to be of the argument?
I've been given a list of issues that has been previously granted by the court in a motion in limine. Some of those I want to revisit, because I think that the way that I'm going to be using that particular issue is important. There is also an issue that Mr. Beckwith tampered with a defense witness in this particular case, Sandra Beckwith. That is Larry Beckwith's wife. And then let me tell you how that happened so the court can get some idea. the court remembers, Larry Beckwith lived kind of sandwiched in the middle of the Keetley acreage. One side, Mr. Keetley's family owned. The other side, Mr. Keetley's family owned. And Larry Beckwith had a small strip of land in between that. There's a road that goes right next to Larry Beckwith's home. And Sandra Beckwith came out with testimony to Detective Lugo and others that on the night of the 24th, which would have been late at night, 24th, 25th, because she remembers seeing on the 25th at 12:30 to 1 o'clock in the morning, she remembers seeing my client driving his vehicle to his mother's house. And if the court recalls, he had been at a party that was all verified. He had been at a party. Mr. Keetley had indicated to law enforcement that, yeah, I got back home about 12:30, 1 o'clock. And so Sandra Beckwith is corroborating that. She was up at that point.
And she's the next witness?
No, but she was up, and so she had witnessed that. She had also witnessed that she had not seen Mr. Keetley's vehicle or the vehicle come back down the road. If the court recalls, being that close to the road, if she would have been up and obviously looking out, you would see those headlights coming up and down that road. So that was a testimony that she was going to be giving. When Mr. Beckwith found out that she was going to give that information, he went to her and he told her, you better not get involved as a witness in this particular case. The prosecution, I guess, the prosecution is going to tear you up because of your mental issues. They're going to bring out some incident dealing with her son.
Is she a witness?
And if you testify, I'm going to kill you.
David Beckwith said he was going to kill her?
Yeah. Sandra Beckwith called David Beckwith's mother and said, David Beckwith just threatened to kill me. And so he went to his mother to discuss, I didn't threaten to kill her, but I didn't want her to testify because that is clear tampering. Now, that's a case for the court and for the prosecution.
What relief are you asking? I don't know what you're asking.
Well, what I'm asking
Another
is
trial against David Beckwith?
No, my ask is a bias. I get to cross-examine him on the fact that he intended to tamper.
Okay.
I get to cross-examine him. Well, it's an issue that they're going to be contesting. Now, if they tell me they're not going to contest it, we can put this case away and not have to worry about it.
Why can't they cross him on that if he testifies?
Judge, I haven't seen the case defense is talking to, so at this point, Sandra Beckwith is not a witness. I spoke with Mr. Escobar about this earlier. If they cross him on that, then I will bring out his depo transcript where he denies all of that. He says he spoke with her, but he denies threatening her. He explains himself. So that becomes a prior consistent statement with what he's saying now.
And he'll also, I suspect, do it on cross, too. He can deny it. And if you have support that you want to introduce of a prior consistent statement, that would open the door to that.
The reason that this even came up is because I gave defense a copy of the multiple motions in limine that the court had previously ruled on regarding David Beckwith's testimony. All of these motions in limine had been granted, and so I wanted to make sure that all parties were aware of what we could not question this witness on, and that was clear.
Does one of those say that they can't cross-examine him on that regarding...
It doesn't talk specifically about that issue. What it does talk about is uncharged crime, and that's going to lead into a second issue I think we need to discuss, which is something that came up in the prior trial. But it's getting into uncharged crime. I think we're dancing on the edge when we're talking about making allegations by defense counsel that this witness should be charged with tampering with a witness, because that is getting into uncharged crimes.
Well, there's no need for that. You can cross-examine on whether he said anything to her, and he's going to say what he's going to say. And if that opens the door for them to then, on redirect, bring up some prior consistent statement, I suspect that I'll allow it. If it's
Judge, I don't mind. I mean, that he's probably going to say that on my cross. But the fact of the matter is he's going to admit that he was trying to manipulate a defense witness into not testifying. That's as plain as day. And that goes to his bias.
Okay, well, I'm not ruling that you can't cross-examine him on that, and if that's not something that's addressed by one of those prior motions in limine, there's currently no prohibition against it. As far as opening the door, well, I tell you what, if you think that anything that happens opens the door to something that was previously in a motion in limine, I'll ask you to approach it that time. But as of right now, I'm not revisiting any motions in limine that I've ruled, because we could do that to, everything that that's why we have motions in limine, that's why I made rulings before trial, so that we don't have to re-argue them during the trial.
Well, Judge, there's one area that now with this new evidence, they didn't do this cross-examination of Mr. Beckwith at the last trial, is my understanding. But there's an issue where you have granted the state's motion in limine concerning the fact that Mr. Beckwith had a bad temper and had to go through anger management, which is what was happening, what he was doing to Sandra Beckwith during that period of time.
I'm not changing my mind on that. You can cross him about whether he told her to change her testimony or not testify. All the things that you just said, you can cross him on that. He's going to give you his answer, and it is what it is. I'm not prohibiting you from cross-examining him, because I think that credibility of a witness is always an issue, and it's a pretty broad scope that the defense can go into. But certainly then he's going to have his answer, and then if you want to get up on redirect and rehabilitate him in any way or show a prior consistent statement, you're welcome to do that.
Judge, may I ask a question of the court?
Absolutely.
When defense is cross-examining Mr. Beckwith on this specific line of questioning, is the court going to allow defense counsel, and I'm not suggesting that they are doing this, I'm just looking forward at all this, is the court going to allow defense counsel to anyway insinuate or directly say, this is tampering with a witness, this is a crime, this is a felony?
That's a legal conclusion that's not for the jury to determine. You can talk about the facts and circumstances that he did without referring to it as being a crime.
Judge, I'm not going to refer to it as tampering with a witness. Okay, I'm going to refer that he was manipulating or trying to manipulate her not to testify.
You can talk about the activities that in your mind would be tampering with a witness, but you're not going to talk about a crime or tampering with a witness. No labels.
I won't. One more thing.
Just the conduct.
I won't. One more thing. In addition to that, Mr. Beckwith was given not only immunity, but transactional immunity, which the court knows is no longer in effect in Florida. You can't give transactional immunity. But when you look at the deposition, what Jay Pruner actually did was, in advising him of the immunity that he was going to get, he didn't say, hey, we can't use this directly, but we can possibly use it derivatively. We could possibly get this information, find more information, and then use it against him. What Jay Pruner said was, we cannot use anything you say against you for any reason. I've got the transcript, and they know exactly what Jay said. And so that is transactional immunity. And so we're going to be filing a motion for judicial notice. You don't have to tell the jury while we're doing the cross. But we're going to be filing a motion for judicial notice for the court to take into account and to advise the jury that not only was he given the first time with a subpoena use immunity, but that the prosecutor, in order to get him to continue to testify, then granted him full immunity from any prosecution of anything that he may have said. And that's on the transcript. It's as simple as day. You and I, everybody here knows how to read the law. We know the difference between use immunity and transactional immunity. And I would concede that Florida has done away with transactional immunity. But evidently Mr. Pruner didn't, because that's exactly what he put in the transcripts, is that he is not going to be, that's not going to be used in any way against him.
So you're ultimately seeking an instruction to the jury regarding what Mr. Pruner promised.
Absolutely, because it's greater. It's greater than what the law allows here. And think about the bias issue.
Do you have any case law to support that in a similar circumstance? Never been addressed before?
We're probably not going to be able to find a cow with four legs here. It's going to be impossible. However, I think we've got some good case law.
Those are pretty common, I would think.
Well,
cows with 4 legs.
Yeah, but not with this particular issue. But we've got a memo that we're going to give to the court for the court to take judicial notice, and then the court can give that instruction at some later point in time to this jury. Because think about it. Let's just think about this. The prosecutor is telling a witness, hey, I can only give you this in guarantee under the law. But you know what? I'm going to give you this.
Okay, hold on. Let me see. Ms. Hodges, what's your position? I don't know. I don't know what
Judge,
Mr. Pruner did or said.
Judge, it's very clear because it's in the deposition that was taken between Ms. Gowdy, Mr. Carr, and Mr. Pruner of Mr. Beckwith. And it specifically says on page 5, starting on line 16, and we haven't discussed this, so it gives you the use of immunity, just like the subpoena that brought you down here when you gave the sworn statement. It goes further in, and on page 6, line 3, Mr. Pruner then again says, and the statements he said couldn't be used against him by the prosecution if there were ever a prosecution of him for anything regarding the statements that are there. So this is immunity, and we have plenty of witnesses testify all the time under immunity, and defense can ask them, you're testifying, you have immunity from your statements. But there's a point where that becomes a defense cross-examination question and not an instruction by the court to the jury. Because just like defense counsel didn't want prior testimony being labeled a court exhibit because it gives greater weight to that statement being when it's purported as a court exhibit compared to a state exhibit, it's the same thing here. When the court is instructing the jury on law that is not relevant to these proceedings, yes, he's testifying under immunity. But to then, for defense to be able to cross him on that, sure, fair game. For the court to instruct the jury on what that means, it gives it more weight. That's not something that's relevant or appropriate. It is, I will concede, fair game for defense to say, you are testifying here and the statements that have been said, that you have said cannot be used against you.
Well, you were told that by the state. I mean, you can go into all of that.
Correct.
This is the problem. I can tell you what. The problem is because these jurors aren't, and I don't mean this in a derogatory sense, they're ignorant over the differences between use immunity. The word ignorance doesn't mean that someone's stupid. They're ignorant in the law. And so these jurors don't understand the difference between use immunity and full transactional immunity. And they need to know that because they need to know what the prosecution did in an effort to try to get Mr. Beckwith to testify and make statements in this particular case.
Okay.
Otherwise, if you don't give that judicial notice, they don't know, which is what we need. That's the whole purpose of judicial notice, is so that they do know the difference. And then they can evaluate and say, oh, was it that big of a difference or was it not that big of a difference?
All right. I respectfully disagree that they need to know the difference. You certainly can go into that he was promised immunity. The prosecutor, you can cross on all of that. They get to hear that, but I disagree that they need to know the difference. That's my rule. So you can cross on it. You can every bit, every word of it. That in any time, for as much for the end of time, you were given immunity. You can go into those facts. Those facts are what's important to them to know. Not the difference between the two types of immunity and whether it was appropriate for him to give that or not. The fact that he did it is what's relevant, and you can cross.
Judge, we'll file the motion, and then the court can act
sure
as you've indicated.
All right.
Okay.
Okay.
Judge, there's two other short issues that the court's willing to address them now.
Always something else.
It's with the same witness, so it's just two other points if the court wants to address it now, or if we want to address it when we come back from lunch.
Let's address it when we come back from lunch.
Okay, sounds great. Thank you.
All right. So technically I haven't ruled on that. So I will consider whatever authority you give me regarding a potential instruction that would be given later and give you the opportunity to submit that to me. I also want to just comment on that I certainly will allow you to cross-examine the witness as to what that meant to him. My ruling is I don't think the difference between use, transactional use, immunity really makes a difference to either the jury or even to the witness, but what it meant to him, and certainly using the transcript, you can ask the witness what it meant to him.
Judge, I respect that. I knew you would, when we found it, you were going to read it and make your determinations anyway, right?
Right.
There is one more that was previously ruled on, but I just want to touch upon this because it is important.
Okay. Well, they're all important, right?
Yeah. The court knows that you have allowed, or will allow, Wesley Smith to come in here and testify that he went with Mr. Keetley onto Mr. Keetley's property and shot firearms.
Right.
We know that, right?
Right.
Okay. Number 15 of the previous motion in limine filed by the government. Let me read it to you. Any direct or implied mention, including purported video footage, which we're not going to do video footage, of David Beckwith and Wesley Smith after the homicides climbing over a fence on the Keetley property in order to target shoot. Now, let me talk about that. We're not going to say that it was...
This was their motion in limine that you can't talk about that?
Yeah. So they don't want me to talk about anybody going over to the Keetley property and shooting a firearm. And let me tell you what the scenario is. At some point in time after the homicide, David Beckwith, as he had done before the homicide, he's not going to admit that he's done it before the homicide, but David Beckwith went to his brother's house where he was living, and with a friend, they jumped the fence in an effort to go and shoot at the Keetley property. And think about this. They felt it was safe because they were shooting at a berm. If you remember the testimony about the berm at the back of the Keetley property, it's very, very important. When he was questioned at depositions concerning that issue, his testimony was, nobody told me that I couldn't trespass on the Keetley property. I didn't have a restraining order not to be able to go on the Keetley property. And, I have a great relationship with Michael Keetley's mother and father, and so what's the big deal? That's important in my case, because to me, I need to establish that familiarity with the Keetley property, because the person that actually went and shot with Wesley Smith was not Michael Keetley. The person that actually went and shot was David Beckwith. And I've got to be able to establish that David Beckwith had that type of familiarity, not only with the property, but with Michael's mother and father, that it was easy for him to just jump his brother's fence. If the court just bears with me, I'm going to show you what I'm talking about.
Did my ruling say that you can't ask him how familiar he was with the family, the property, or anything?
I can't even ask him whether, in fact, he jumped over the fence and shot with someone else on the Keetley property. I mean, that's what is dumbfounding me. But let me show you. You want to approach with me so we can show? This is Bonita Drive. This is the Keetley property.
Mm-hmm.
There's only a very tiny little strip here that belongs to Larry Beckwith. This little strip right here belongs to Larry Beckwith. There's a gate back here where you can get from Larry Beckwith's property onto the Keetley property. This is where the shooting supposedly took place. I need to be able to establish David Beckwith's ease of being able to come over here and shoot. And he, in his testimony and deposition, he said, yeah, nobody told me I couldn't trespass.
What was it that the state was trying to keep out? Did he had the ease that his property was right there and he could easily go onto the property?
No, Judge, that's not the basis for the motion in limine. So the court's ruling, because these were already litigated and the court, it looks like October 5th of 2015, ruled on all of this. So in the limiting issue that defense is bringing up, the exact language is any direct or implied mention, including purported video footage of David Beckwith and Wesley Smith after the homicides, climbing over a fence on the Keetley property in order to target shoot. The court granted that motion in limine, and I guess the date this was filed on October 5th, but the court granted that motion in limine on March 17th of 2016. So that was
Of when?
granted.
What was the date?
March 17th of 2016.
Was I the judge?
I don't know the answer to that.
I don't think so.
However, I mean, defense can absolutely question Mr. Beckwith about
How
his
familiar he was,
familiarity
how
with the
close his
family.
access was, the ability, even that he shot there with other people, but not that he climbed over the fence. Yeah, so I mean,
Why not climb over the fence? I mean,
why do you need to climb over the fence? That makes it less accessible, right? He's got to actually climb over a fence.
No.
When you rather they not hear he has to climb over a fence?
You'll remember that, okay? Because that was the time that he actually climbed over. But if you don't want me to say climb over the fence, I won't.
That's what I'm not letting you say. Climb over the fence. His
Yeah, 'cause
accessibility,
he was not-
his ease. First, we're talking about how easy it is to get there. Now we're going to throw in a fence. You're making it less easy.
I'll take the fence out.
Take the fence out.
Okay, it's out.
There are prior convictions for Mr. Beckwith. Defense has shown me 3 certified convictions.
Mhm.
I've spoken with Mr. Beckwith. He understands it is 3. I've spoken with defense. In the prior trial, he testified that there was 4. And so Mr. Escobar and I agreed that for the purpose of this case, it's 3.
Okay, you're in agreement?
We are, Judge.
All right, because that's how many certified copies there are?
I got the certified.
All right, so you've instructed him,
I have.
and he's going to testify accordingly, appropriately, and accurately.
I have. Yes, sir. Last thing that I wanted to address. In the prior trial, Ms. Gowdy asked a question of Mr. Beckwith. And it was a series of questions. You were in possession of a firearm on this day, and one of her ultimate questions on this line was, and as a felon, what are you not allowed to possess? He didn't answer the question, and his answer was, you tell me. And Ms. Gowdy says, firearms. The state then objects. The court sustained that objection. So knowing that the court sustained that objection, I don't want us to go down that same road and that same line of questioning in regards to an aggravated assault or a felon in possession. Defense can ask the questions of, did these facts occur? But if we're going to insinuate and impeach by improper, uncharged crimes, the court has already ruled that is not admissible.
Well, but how do we know? I don't know that it's the initial question of what are you not allowed to possess. And if he knows the answer to that, and he answers correctly under oath today, I'm not going to prohibit that.
He will say that because in depositions he says, yeah, I'm not supposed to possess a firearm. That's
yeah.
huge.
I think that what I sustained was Judge Attorney Gowdy testifying. He asked her a question and she answered it.
What the court sustained was the ultimate conclusion that you are breaking the law by committing a felon in possession. And so there's a difference there. The facts can come in. The facts that
he's a felon, and he possessed a firearm, and that he's not supposed to possess a firearm.
Well,
those are the facts.
And the court sustained that before, saying that counsel should not have gotten into that.
No, what you read to me was he asked her a question, and the state didn't object until she answered the question. So my thought, I don't remember it specifically, I don't have an independent recollection, but from what I'm hearing...
I think Leanne said, you committed a crime by possessing a firearm.
I won't allow that.
And that's what you didn't allow.
I'm not going to allow that.
Right. But I'm going to ask him, and he's going to
the fact that he knows he's not supposed to possess a firearm, and he was possessing a firearm is fair game.
Yeah.
Credibility.
Yeah.
Well, and Judge,
specifically credibility.
Credibility as to he possessed a firearm, but improper impeachment by uncharged crimes by going that step further and then saying that's a crime, that's a felony, I
don't know. I'm willing to break the law. A witness testifying to that is fair game as to credibility of a witness. I'm not going to allow them to say, but that he was a convicted felon, that he possessed a firearm, and that he knows he's not supposed to possess a firearm is all I'm going to allow. A conclusion that he was committing a crime because it was an uncharged crime is where I won't allow you to go. And I won't allow you to answer his questions. So don't just tell him that you'll ask the question. So if he asks you, you tell me what I'm not supposed to possess. I don't want you to answer that.
I won't.
Your Honor, I apologize. There was one thing also briefly with Ms. Hodges
yes.
As it relates to Mr. Durr, which I believe is the next state witness.
Yes.
Who? Durr?
Robert Durr.
Durr's next.
Yes, sir.
Yes, sir.
Yep.
I was discussing with Ms. Hodges about a couple things, what's coming in, what's not coming in, and we're at a disagreement about one particular, or I guess two particular items.
And you're crossing Durr?
Yes. Two particular items, the magazine and the firearm that was found within the vehicle, swabbed for fingerprints or lifted for fingerprints.
Right.
Ultimately, nothing came back with comparable value. Our argument would be irrelevant, prejudicial. There's no reason for it to come in. It plays no material fact.
If they swabbed it and nothing came back?
Correct as far as fingerprints. I don't want to say the wrong thing about
Judge, the
DNA.
testimony I intend to elicit is that the defendant is, that there's a vehicle process. Prior witnesses, well, actually the witness who will testify that he was stopped in that vehicle will be a recorded interview, or recorded prior testimony that'll be played later. But the vehicle the defendant was stopped in is going to ultimately be put before this jury, and that Robert Durr is a crime scene investigator. He processes that vehicle. There's a Jimenez 38 in there, which is a firearm. That firearm is recovered. It is swabbed. There's no evidence of any DNA that's going to be presented off of that gun. But when we're talking about firearms that are being excluded as potential firearms in this investigation, we can show that this was a firearm that he was in possession of, that law enforcement recovered, and it's not a .45. It's not the gun in question here, along with all of the other firearms that we've introduced previously, that we've had witnesses testify to.
Okay.
This is no different.
The defense objection is relevance, that it's not relevant since
Well, it's not
they
relevant
swabbed
given
it.
the swabs, the prints, and then at that point it becomes prejudicial to try to keep piling on all these different firearms when that's not even the point that the state's trying to make, that this wasn't the firearm that they're alleging was even used in the crime.
What about the response to that it becomes prejudicial with all the extra firearms?
How? How is that prejudicial when we're introducing other
He
firearms?
has
We're showing
an
that law.
artillery of firearms.
So one additional gun is going to be what makes a difference on that. The defendant is in possession of this firearm in a vehicle when he's stopped, and law enforcement's doing a thorough investigation. And that's the heart of defense's case, that law enforcement is not doing a thorough investigation. So if we're going to sit here and say that law enforcement can't say that we recovered a firearm from a vehicle the defendant was the sole occupant of, and that we didn't do anything with it, we just tossed it to the side because we didn't feel like processing it, that sets up the argument for defense that, well,
I think they're suggesting that he shouldn't be able to testify that they even found a gun because the gun is unrelated. There's no proof the gun is related to the crime, so why is it relevant?
it's relevant because we have weapons that are in the defendant's possession, and law enforcement is doing a thorough investigation. They are able to recover these. They are able to process them. And they are able to say, we get no evidence off of this to suggest that the defendant's prints are there, the defendant's DNA is there. Short of it being in a vehicle that the defendant is driving, a vehicle that was then something that was impounded by law enforcement as a two-tone vehicle.
Well, but what is that at what? I mean, relevance is defined as tends to prove or disprove a material fact. So what material fact is the fact that he had a gun that's completely unrelated, that you can't show is related to this crime that's on trial here in any way, other than they did a thorough investigation? But if the jury doesn't hear they found a firearm, they're not going to suspect that they didn't do a thorough investigation by not swabbing it, printing it, sending it off. So their objection is to the fact that a firearm that's unrelated to this crime at all was in the car. That it's not relevant because it doesn't tend to prove or disprove any material fact in this case. So I guess my question is, what material fact, not whether law enforcement did a thorough investigation, but the fact that he had an unrelated firearm in his car, what material fact does that tend to prove or disprove?
I'll answer the court's question probably with a question if you'll allow me. So
we could try.
If the court is going to say that we are not going to be allowed to talk about there being a Jimenez or a firearm found in there, I think it is relevant to say, to ask the question of the witness, was a Glock 45 caliber firearm found in that vehicle?
And the answer is no.
no.
Yeah.
So that's the ultimate point we're getting
Okay.
to is the car was completely searched, a firearm was found, and it's not a Glock 45.
Yeah.
So if the court's willing to allow me to ask that question in the negative, that should address defense's concerns.
Yeah, I don't see why. I think that's relevant, that they didn't find a Glock 45, but I don't think that there's any need to get into any, everything else they found that's not related to the crime here.
So what I'll do is I'll instruct my witness that I am going to ask a specific question. When you were searching that vehicle, was a Glock 45 found? The answer is no.
And it is technically a leading question, but I'll allow the leading question. We're just not going to talk about other things that don't appear to be relevant. And I understand that had it been talked about being found, the fact that they printed it, all of that, would also be relevant because that would prove that they, conducted a thorough investigation. But if it doesn't even come up, then that eliminates all the rest, the need to prove a thorough investigation, because they don't know that they did or didn't do it.
I'll instruct the witness prior to his testimony.
All right. Did you need to be heard on that?
No.
Okay, that's my ruling.
Was there something else you needed to address?
I think it was just
I think
that
that's
was,
enough.
What was that and the magazine?
There's always one more. The magazine.
I was putting them in conjunction.
Well,
because it was
let
the
me
same
ask:
argument.
is the magazine a 45, or does the magazine fall under the same, not related?
Yeah, no.
Okay, so we're leaving the magazine out.
Just wanted to make sure that they were in
now and
conjunction.
let him know.
Go ahead and we'll line. Are they already lined up?
Before we line them up, I got a question.
Oh, yeah. A juror asked one of the bailiffs a question. Is that the one we're going to talk about?
Yes.
But let me find it on here. What was the number?
15.
Seat number 15?
Seat number 15.
All right. She's an alternate.
Yes. So you approached me downstairs when they came back from lunch and approached Deputy Krisman with the same question when she was taking them out.
Right.
The question from her, she wanted to know is, of the last two videos, what was the time frame of those videos, because she didn't hear anything about it.
That's very important.
She was inquiring regarding the date. I don't know if anything was the date given when it was announced that it was being played?
Especially the Channel 10, I think that's very important.
I'm sorry to interrupt, go ahead.
The Channel 10, I think, is extremely important to have a date affixed with that video because of the time sequence.
Well, but here's also the thing. We don't normally let jurors ask questions. Unfortunately, occasionally it comes up where they ask, and the bailiffs know enough to come and tell me. They were told that they can't ask questions, but then they told me that they asked a question. So the response to them was that you can't ask questions. So, though the deputies did the right thing of letting me know what the juror asked them, so I wanted to let you all know, and then so we could figure out how to handle it. I certainly don't want to open the door to every time the jurors walk out that door, they're asking follow-up questions to the bailiffs that they bring to me, and I come in here and then we decide. So that's my little bit of a concern there.
May I make a suggestion?
Yes.
So I think we have the unusual opportunity here to have the advocates know what's in at least one juror's mind. I don't want the court saying anything about the question. And if either side chooses to put that in their case, so be it. But I agree with you. I don't want to say, hey, here's a question, let me give your answer, and everybody else starts asking their questions. So that's why I suggest
Well,
that.
it could be done this way if the state agrees. I could simply ask the state, what was the date of the videos, or the state could just stand up before they call the next witness and just say, we want to put on the record the date of the witness testimony and then the date of exhibit, whatever it was, 179, or I don't remember the number.
Judge, I think in the stipulation we specifically addressed with regards to the testimony, not the Channel 10, that they're not to concern themselves with the time or how old that testimony is, something like that. I can't remember the exact wording.
Well, what it said was, it says, do not be concerned with the type of hearing or age of the case. It's a little more specific than and they know that it's 2010, so it certainly isn't opening any door that they're not already aware of if we were simply to put on the record whatever date those two items were.
Judge, I will have to go check about when the interview and the news story came out. I know that there specifically is a reference within the news story itself referencing the shooting, and I believe, I'm going from my memory, it either says a couple or a few weeks prior, a couple weeks. So there is a time reference within it. If you want me to find out exactly when the story was run, that doesn't necessarily say when the interview happened. but there is a reference to the news story itself. And Judge, I know when we do any sort
That's
of
true. No, I remember that. The reporter said something
Yes.
that it had just happened.
Said it happened a couple weeks ago.
Right.
Didn't give a date. But here we've got this problem based on what a juror is asking, because Ms. Doherty's right. You don't know where the footage took place. We don't have the whole footage. I know that was litigated previously. So,
But Judge, I think it's fair for us to comment in closing and reference the time frame given in the video, and the jury can make any conclusions about that as they see fit. I don't know. If
What
this-
about the other one, though?
The other one, I don't necessarily think that if you want us to give the date of the trial of when that testimony, we can certainly figure that out. But normally, even when we do motions to perpetuate testimony, they are to view that just as if the witness is testified in trial. This is a witness who is unavailable, and so I know that we didn't include the date or the time, but when we certainly were talking about the age of this case and not to concern themselves with the other attorneys that they see in it, so I don't necessarily...
Well, let me ask you this. So normally, a lot of times when we're either doing a specific deposition to perpetuate testimony or we're reading a prior deposition because a witness is no longer available, my belief is that we do read the date and time of the deposition, or at least the date of the deposition when it's presented.
I don't know that that's always the case. I think if I get my rules with Florida and federal sometimes mixed up, I think it's 613 or 614 says you control the mode of interrogation, presentation of evidence. So I think you can use that rule to do that if you feel that it's appropriate. But I don't know that it's necessarily a requirement. I don't have any problem either way. Ms. Villamil reminded me that when he testified, Mr. Bose at some point in time said, and this was 10 years ago, so he did give some type of time reference similar to what we have in
That's true, he did.
Channel 10
He did.
testimony. I don't have a problem
All right,
anyway.
so-
What I don't want to have happen is for you to address us, or particularly the state, either party, to say, this is the information I want because of a juror's asking that question.
And I agree. And I wanted, because the bailiffs brought it to my attention
Right.
that there was a communication, I wanted to give it to you all. But this is what I'm going to do. I'm satisfied now that there's enough within what was presented to them that you all can do with it what you want in closing. So I'm not going to address it.
Okay.
All right.
Judge, can I just check with Michelle?
Yes. That is our third alternate juror, so hopefully there's a very good chance that we won't go through enough people that that juror is even going to be back there deliberating.
Well, we're keeping people awake today, apparently.
I have been watching also. I appreciate that. I've been watching seat number 3, formerly number 71, and he has been very attentive throughout the day. But, is that because he hasn't done a cross?